Lordship.
Yes. I have a prayer for listing this matter tomorrow, madam. So there's some urgency. I filed it yesterday. Motion it.
What is the matter about?
My lord, it is matter relates to filling up of a post, promotional post to DPC. My name is already on the top of the list, extended panel. In spite of that, they are going. Tomorrow. Much obliged.
My lord, I beg to mention, my lord, one suspension matter, my lord. It was listed before the court number 20, my lord, but this court did not take up matter. So may I pray for listing the matter for Monday or Friday, my lord?
Why? What is the urgency?
Urgency, my lord, the suspension matter, I am going to retire very soon. My lord. 22 matters.
When are you going to retire?
I am going to retire, my lord, August.
Next week.
Any
This
date,
week.
Monday, my lord.
Your Lordship, on admission matter to be fixed after any date after the vacation, Lordship.
May it please your Lordship, I beg to mention an item for listing tomorrow. Lordship, it is an IA we have filed yesterday. We failed to actually extend the interim on the last day it came. Lordship was pleased to give us an interim. So for that matter, we are filing an IA for extension of the interim. Highly obliged.
Lordship, item number 14, I have received an affidavit in opposition. I will file the reply. It may be taken, Lordship, after 1 week. 14. Item number 14. Mr. F.Z. Majumdar, learned counsel for the writ petitioner submits that 3 weeks time is required to file a rejoinder affidavit on behalf of the petitioner, since the prayer is not opposed, and therefore the matter be adjourned accordingly. Since the prayer is not opposed, same stands alone, that the matter be listed accordingly.
May I please, Lordship? Lordship, I beg to mention item number 15, Lordship. Orders matter. Lordship, matter is infrastructure, Lordship. Petitioner was expired, Lordship.
Acha. Mr. P. Sharma, learned counsel for the writ petitioner submits that his client has already expired. Now, already his client has expired, and therefore the writ petition has become infructuous in view of the relief that has been sought in the matter. We'll stop. Taking note of the submission of Mr. Sharma, this writ petition stands disposed of as infructuous. Any interim order?
No, Lordship. Obliged, Lordship.
May I please, Lordship?
Yes, please.
Lordship, I beg to mention for listing of writ petition. Lordship, it's a 2011 year matter and was last listed on 13/3/2023. As per the court's order, the court have ordered to file an affidavit as the parties have settled the matter amicably. So kindly the matter may be listed on 15 to dispose the matter. Kindly oblige.
15th is day after tomorrow.
Yes, Lordship.
Yes.
Item 1.
Yeah, my lord, the present writ petition relates to seniority of the petitioner as he claims seniority over the assumption of 5 and 8. And that too from the effective date of, that is 1/10/93. Although the present writ petitioner already retired on superannuation, and in the post of general manager, he was holding, then at present, he has been deprived from getting the notional benefit. The notional benefit.
No, Mr. Bokar, he wants seniority.
Yes, yes.
After he gets his seniority, he will want a DPC to be constituted, to be promoted, and then to get financial.
Yes, yes.
benefit. Not permissible under the law. You show me a judgment, I'll pass that on.
Here, what happened? These two persons, 5 and 8, these were juniors to him.
No, that's on facts.
Yes.
But since he has retired, now this relief cannot be granted to him. What is the point in giving him seniority?
Only the notional benefit I want, because the income, it affects my income also.
Notional benefit, he will get only if he is promoted.
Yes.
Now it cannot be considered.
No. The promotion, the question is the notional benefit, he cannot be deprived. Because these persons who that is on 3F, they were given the regulation 3F. In regulation 3F, after 3 years, they were regularized. After regularization, they will not get the benefit of with retrospective effect. There is the crux of the whole case. So nobody can deprive my notional benefit, my lord. Is it wrong on the part of the authority concerned? And he also ruling also supports me.
Petitioner retired before filing this writ petition, is it not?
Yes.
He retired in 2004. 6 years after his retirement, he comes to the court saying that I am senior to the private respondents. So give me the seniority,
No,
then
I don't want
consider my case for promotion.
only notional income, notional benefit I want.
Notional benefit on what count?
That is because
Hmm.
that is to be considered, my lord. That is to be considered. That is true.
You argue the matter, but it cannot be done.
But it will, my lord, let me confirm from him whether he was there. Because it's a long pending
This
case.
is your pleaded
It is.
case. He retired on
It's a case of-
31st of August
It's a
2004.
case of 2010. So he came up that day. My lord, actually, let me check up.
Acha, you argue your case. You argue your case. Make your submission.
No, my lord, here, the writ petitioner paid for this writ petition here, the judgment against 6/3/2010. And the judgment was passed by the Assam Administrative Tribunal, Guwahati, in case number ATA/08, whereby the appeal of the petitioner has been dismissed. So against the dismissal order passed by the Administrative Tribunal, I have come. Now,
Yes, let us see the order of the administrative tribunal.
that is the order at page 176.
176. Yes. Yes.
He claimed that he had been superseded in the year 93. Then piece 177, not promoting him to the post of general manager, director of industries. It is by his juniors Indrasanath and Sri Niharanjan Sharma had been promoted in 93, sorry. And therefore, in view of that, he had retired on superannuation from the post of GM. And he paid for notional fixation of pay in the post of general manager, director, with effect from the date of appointment of his juniors. So it is calculated with in 93. This is the effective date of promotion. The next paragraph. Government has put in further content that in spite of the order, the tribunal in ATA/87/92, they are so and so, suggesting the appellant to move the Honorable High Court to implead himself as a party in the proceeding initiated by Niharanjan Sharma. As for number 9, informing the same, wait, the appellant did not implead him as so and so. Now, next, page 178. It is saying that appellant originally filed a case 87/ATA/92 in the year 92. Claiming higher seniority over respondent 6 in the gradation list of function managers, etc., in the industries department, or hearing the matter, the tribunal by an order, there 33/293, held that the issue involved in the case will also need consideration of the Honorable High Court in a proceeding initiated by one Niharajan Sharma, the tribunal therefore ordered that to avoid much conflicting decisions on the basis issues involving the case between the tribunal and the Honorable Guwahati High Court, the tribunal considered it expedient to await disposal of the proceedings by the Honorable High Court. So it was awaited. The tribunal therefore ordered for disposal of the said appeal with liberty to the appellant to revive it if it considered necessary. To do so after Honorable High Court disposed of the aforementioned proceedings and suggested that both the appellant and respondent number 6 may move before the High Court for making them also the parties. It appears from the record the number of writ petitions filed before the Honorable High Court in respect of the proceeding involving seniority of the appellant and respondent number 6 and 9. However, it is seen that from the evidence made by the appellant, he did not implicate himself as a party in the proceeding before the Honorable High Court. It was against by the tribunal. The appellant may implicate him is a party in the proceeding before the Honorable High Court. The appellant did not make him a party. So, however, the judgment ordered 28/4/2005 passed by the writ petitioner, party writ petition in respect of the matter, appellant reported back to the tribunal on 31/1/08. As a tribunal by its order dated 3/2/93 in case number so and so 92, granted liberty to the appellant to revive the case after Honorable High Court disposes proceedings involving the case. The appellant has approached the tribunal on 3/1/08 for revival of the case after disposal of the proceedings before the Honorable High Court. Although after making some delay, we therefore are inclined to hold the view that the delay should not deprive the appellant from approaching the tribunal. As the appeal is not barred. So that is about the fact. Now, order started so and so. The line number 4, serial number 2. Under Regulation 40 of the APSC, limitation 51 in 1986, he was regularized by the government in November 86. Whereas the respondent number 6 and 9 was initially appointed in the post of function manager, deputy director under Regulation 3F of the APSC, LNF regulation in 1984. And subsequently regularized their service in the post in the year 87. So they were appointed in 84 and regularized in 87. Learned Counsel further argued that any appointment under Regulation 3F of the APSC being temporary and ad hoc in nature, and hence only after regularization by the APSC, the said appointment becomes regular. Hence, as the appointment of the respondent was regularized in the year 87, both respondent number 6 and 9 cannot be treated as senior to the appellant in the gradation list of the function manager. The appellant and submitted the respondent number 6 and 9 are directly appointed under Regulation 3F of the APSC regulation in the post of function manager deputy director year in the year 84 and subsequently regularized with the approval of APSC in the year 87. With effect from the date of initial appointment 84, the senior to the appellant and hence gradation list of function manager so and so of the finally published by the government Recruitment and Seniority. Number 3, it is in the Annex 7 of the appeal, petition gradation to a function manager, director of industry department had been finally published in 91, where position of the appellant serial number 45, whereas the position of the respondent number 6, April is serial number 42. And that of the respondent number 9, was a serial number 32. We noticed that nowhere in the appeal, the appellant complains that the government respondent had not invited objections for the incumbents. It appears from the record that the applicant was promoted to the post of Deputy Director of Function Manager under Regulation 4D of the APSC regulation in the month of July 86, and was regularized through APSC in the month of November 86. In the other hand, applicant number 6 and 9 were appointed in the month of 1983 as function manager and under Regulation 3 of the APSC. Therefore, both of them appear in the interview before the APSC. Thereafter, both of them appeared in the interview before the APSC for regularization of the service for the post of function manager and deputy director, and said interview was held in the month of October 84. Both aspirant number 6 and 9 were selected for the post of function manager. The aspirant number 6 secured 11th position, whereas the aspirant number 9 and 9 secured 10th position. In pursuance of the aforesaid selection, the government of Assam appointed 7th function manager from the select list, as both aspirant 6 and 9 were left out. This will be clear, my lord, if I submit you for some important documents. Page 68 to 85 of the married pension. '68 to '85. Your lordship got it 68 page.
Age?
68. 68.
Yes.
And particularly about a 72 page number.
No, Mr. Bokatagi, what is the basic case of your client? Your client was appointed as functional manager
Yes.
after the respondent 6 and 9, correct? After the respondent 6 and 9, but he was regularized prior to 6 and 9. Subsequently, 6 and 9 was regularized with effect from their initial appointment, which
Initial
is
appointment.
before your client.
Yes.
Have you challenged those order of regularization?
Yes, yes.
What has happened to that? Where have you challenged?
There are big argument. This series right from page 72
No, in which proceeding have you challenged that order?
before authority concern also.
Challenge before authority.
Yes.
Challenge is before the court, not before the authority. Have you challenged it in any court? You means I am asking about
Yeah.
your clients. Have you
Before
challenged-
the administrative tribunal.
Right, so the tribunal has given a detailed finding that they are senior to your clients in the post of functional manager, so they were rightly placed higher than your client. And therefore, they were promoted before your client.
The observation and the finding is quite illegal on their part, because it cannot be so. Once a person is appointed for a regulation 3 years, and after 3 years he is regularized, you will not get a retrospective.
No, but that order is not set aside. Where is the challenge to that order?
Yet. It will come here, my lord.
Where? Show me. Where is the relief to set aside that order? Where is the prayer? There is no
Because
such prayer.
he became functional manager in
No, I'm asking a very simple question. Has your client challenged the order of regularization of service of respondent number 6 and 9 with effect from their initial date of appointment. That's all I'm asking. They were
Yes.
appointed under 3F.
Yes, and if you look for first in the year 92, before our
Where is the challenge? Where have we challenged? Where is the prayer to set aside their order of regularization?
that is my lord. Please. Because this judgment is self-explanatory. The judgment will be is a self-explanatory. Because it doesn't, there is observation given in the judgment also. From very inception till last judgment passed. Is clearly, it is, he is the senior in the draft, in the final condition list, everywhere. That is very much relevant.
Where is the order dated 28/4/2005 passed by this court in WPC 7263 of 2003? Mr. Kalita, where is that order? 7263 of 2003.
It is a page 120, your lordship. Page 120. So it has been affirmed, lordship, actually. It starts from page 119.
He did for all superannuation on 31/8/2004. It is nowhere stated by the court like a tribunal. They just time border like this, or they have no right to appeal. There's no such observation. The only thing, what I feel, that with the regulation 3F, there is misunderstood by the authority council as well as by the court.
So have you got any authority in support of that? Any judgment?
That is one, is the one. And you see page 3. I have considered the rival submission made by the Lorry Council of the parties as well as the entire matters on record. I do not find any informity in the finding recorded by the tribunal that the ad hoc service of the petitioner involved in so and so cannot be counted to a seniority law. Law in this regard is well settled, in terms of which the ad hoc service rendered before selection for regular appointment cannot be counted for seniority. The appointment of the petitioner prior to this election for the Assam Public Service Commission, being regulation 3F of the Appellate regulation, he is not entitled to count his seniority for a set period. But his seniority will have to be counted from the date of appointment pursuant to regular selection in the district.
Right. Anything else?
Merely this much, my lord. That is because if your lordship says or observed it, after so many years he has come, yet I have nothing to say. And otherwise, there was nobody objected about this. Twice he went to the tribunal also.
So your client retired as what? In which post?
General manager.
Sorry, general manager.
General manager. The post of general manager / joint director on 31/8/2004.
And he was promoted as general manager when?
He was promoted.
In 95, your lords.
Can you give-
17/10/95. With effect from 17/1/95.
Let me see.
And the private respondents were promoted earlier to him.
Yes, Lord. Yes, 93.
So he wants that his promotion should be given retrospective effect
Yes, yes,
and his scale should be refixed.
correct. That's
And
what
he
he is.
should be given notional benefit.
Lordship, Lordship has seen that judgment and order of this honorable court, single judge's order. So in that case also, Lordship, the issue was actually between this respondent number 5 and 9. Because like 5, there was a contention that in the APSC select list, respondent number 5 was
That was an inter-se matter between
correct.
them.
Interesting matter. In that matter, Lordship, actually, when he approached the Assam Administrative Tribunal, the direction was given that he should plead there because he may be also affected.
That was not correct.
Yes, he did not.
But,
So this has come to
liberty
a
was
final
given to
result.
him. Liberty was given to him.
But he did not.
To come back again, he can.
Absolutely. That is how
now
they've
that pro-
entertained.
And he did.
They've entertained the appeal.
Yes.
Yes,
But they've ruled against your client.
correct.
That's all. What else is there?
But,
Mr. Bokotaki, your clients did not challenge the order of regularization in service of respondent numbers 5 and 8 with effect from the date of joining, which was prior to the date when your client was appointed or promoted as functional manager. Is that correct? I'm just asking a simple question.
yes.
Is that correct or not? You are a seasoned counsel, you give the answer. Is that correct or not?
I cannot say this incorrect, my lord.
Then let me dictate the order in the chamber. You have done your job. I'll go through the file again and yes.
Kindly, your lordship, I will be happy if your lordship goes through the files.
Yes, yes, I will. We always try to give relief
Yes, ma'am.
wherever possible.
If yes,
If it is not
any
possible,
law is
then
against
nothing
me, I
can
have
be
nothing to say. If any law is against me, I have nothing to say.
Yes, law is against you because your clients did not
Yes.
question the regularization.
Then I have nothing to say.
Nothing
But
can
here,
be
my
done.
lord,
Yes,
yes,
you are appearing for whom, Mr. Khalid?
Industries department, industry cost.
otherwise, in the case of 2010, my lord, if there is
No,
some.
it is not only for delay. First, he must have a case.
Yes,
The judgment you have relied upon, please go through it once again. The issue was whether the benefit of seniority can be given for the ad hoc period of service. Here, the ad hoc period is not there because their regularization dates back to their appointment.
kindly
So
say,
that order judgment does not help you anywhere.
that what-
Anyways, we move on.
That's what I have forgotten because of 2010, my lord. And yesterday only I have seen, my lord.
Then it's all right. It's all right. Yes.
May I please, your lordship? My lord, in this case, my lord, the petitioner was, my lord, engaged as extra writer in the office of district register Karimganj, my lord, by annexure 1, page 17, my lord. The deputy secretary by or to the government of Assam Revenue Division thereafter by notification dated 19/5/89 communicated the government's decision to give a regular scale of pay to the extra writer who has served 7 years up to 22/12/86 as extra writer in the department. My lord, annexure 1, page 17. By which, my lord, the petitioner was engaged as extra writer in the establishment of, my lord, district register Karimganj.
What is petitioner is working as what?
He was working as extra writer, my lord.
He was means he is not in service.
Then, my lord, his service was regularized by
Yes.
by annexure 2, my lord, page 18. Thereafter, my lord, by annexure 3, there was a writ petition filed by the filed before this honorable court, and this honorable court by judgment dated 7/11/91, my lord, was pleased to direct the government, my lord, that the extra writers who have put in 3 years of satisfactory and continuous service as extra writers should be absorbed in the cadre post of LD assistant in the department with all consequential benefit. Annexure 3, my lord, your lordship will find at page 20.
What is the relief you are seeking? Here?
Yes, my lord. Now, my lord, I have been, my lord, thereafter, my lord, as per annexure.
What is
16.
the relief you are seeking, Mr.?
My lord, I have been given appointment to the post of LDA, LD assistant, my lord. But the retrospective effect has not been given from the date of my regularization of service, my lord, 1/8/88, my lord. That is my grievance. My lord, by this, my lord, whereas the respondent number 5, who is junior to me, my lord, he has given to the.
So
the
when you were
appointment-
appointed, you were appointed when?
I was engaged, my lord, on 1/6/1976.
You were engaged as?
extra writer. My lord, under the establishment of district register Karimganj.
Where is the order?
My lord, page 17, annexure 1. My lord, respondent number 5, who is admittedly my junior, my lord. He has been given.
Oh, don't start. You give me the facts.
My lord,
This is your submission.
my lord. Absolutely, he is my
Give me the
junior.
facts.
Yes,
When was your client engaged? I am asking you.
yes,
You
my
are
lord.
again and again going on.
1/6/1976.
1/6/1976.
My lord.
Where is that order?
My lord, this is the order, my lord, annexure 1.
Annexure 1, the date of the order is 1/6/1976.
No, my lord. Notification dated 19th May 1989. My lord, your lordship will
When
find.
was your client engaged initially?
My lord, if your lordship pleases to see, my lord, the gradation list, my lord.
All right, I'm reserving the order. Dismiss it.
No, my
I'm
lord,
asking you questions, you are not answering.
Yes,
What
my
is this?
my lord, 1976.
Where is that order? 1976. Where is that order?
It is not been annexed, my lord, but the notification is annexed, my lord, wherein it is stated, my lord, that, my lord, your lordship will find at page 17, my lord, pending formulation of the finalization of the service rules extra writers engaged in different registration offices under the registration of the Department Government of Assam is pleased to declare the regularization of the services of the extra writers whose continuous service up to 7 years, 7 years up to 22/12/88 lists, which are being separately after observing relevant formalities of the government. My lord, this is the notification, but list is not annexed. My lord. This list is not.
Nothing can be done.
Therefore, my lord, but admittedly, my lord, I am, my lord, engaged on 1/6/1976, my lord. That is,
My lord, the
My lord.
petitioner and the respondent, all are, my lord, they are not in service. They are already been retired long back, 2015 and 2017.
no, but the
My lord,
notional
the lordship
benefit, my
can
lord,
see
what
the fair portion.
no,
What is his fair portion?
my lord, your lordship kindly, my lord, your lordship kindly bear with us, my lord, that I am praying for the notional promotion and notional
That is
benefit.
not mentioned in the, my lord, fair portion.
My lord, your lordship, no, my lord. In a prayer, your lordship will find, my lord. In the
So
paragraph,
you have got the reliefs you sought here.
no, my lord.
Insofar as your absorption in the cadre of LD assistant is concerned, that has been done.
That has been, but the retrospective.
The retrospective, you are not asking, you have not paid for that.
Well, but the law is law is clear, my lord, on that point, my lord, that, my lord, I have got the Supreme Court judgment, my lord.
Retrospective,
Say-
your retrospective is not a hanging mango in a tree that you will come and stretch out your hand and you will get it. Retrospective, you have to show what is your right that crystallized at that point of time. You don't even have the order of engagement.
My lord, your lordship, my lord, can your lordship, my lord, have it on Thursday, my lord?
No.
I'll,
None
my
of this
lord, yesterday
top
evening.
of the
brief
list
was handed
matters
over
will
to
not
me, my
be.
lord. Yesterday evening.
I'm so sorry.
My lord,
We can have it at 12, not beyond that. Yes, call it again at 12. Top of the list matters will not be engaged, except for
my
a,
lord, yesterday evening.
I'm
I
so
was-
sorry, 12. In 1 hour, if you can improve your case, beyond that, it will not be possible. And we have to maintain a consistent stand in all matters.
That's true, my lord. I understand.
I'm
my
so
lord.
sorry, can't
That-
be.
my lord,
You don't have any case, Mr.
Lordship
Mr. Sen.
can, my lord, only accommodate single day, my lord.
For your satisfaction, I'm giving you 1 hour. Otherwise, I could have finished off dictating the judgment by now.
No, my lord. I-
Take 1 hour and see what you can do. Yes,
My
next matter, please.
Well, in this case, we have entered evidence today, Malad.
It will not be a
No,
job.
that's okay, Malad. Well, it appears that Malad, the government side doesn't file an affidavit till date, Malad.
You argue, if you
Yes, Malad.
succeed, you will get the relief.
Well, what happens, my lord, the petitioner, my lord, he appeared in a selection process that was advertised through the employment exchange, my lord, in district Kasar, my lord. For advertisement was over 25 posts of junior assistant, my lord, under Deputy Commissioner Kasar, my lord, establishment of Deputy Commissioner. And my lord, although my lord, the advertisement is not annexed here in the petition, my lord.
No, first of all, please tell me, what is this matter about?
My lord, the
Because
petition-
we have to now read these briefs in the court. Huh?
Yes, my lord,
I have not gone through these briefs.
my lord.
What is the case about?
Case is that, my lord, the petitioner appeared in the selection process and he was selected, his name was at serial number 17 of the selection process that involved
Selection process to what?
to the post of junior assistant under the establishment of Deputy Commissioner Kasar, my lord.
Yeah.
And my lord, his position was in serial number 17. Then what happened, my lord, he was suddenly, my lord, called, he was given appointment, not for the permanent post, but for under a contract, as a contractual, my lord, account assistant.
When was the appointment made?
My lord, under the contractual establishment number, dispatch number 3, my lord, he was first engaged on 29/10/2009. Page 14, my lord,
Yes.
as an account assistant. And thereafter, my lord, his engagement was, my lord, extended from time to time, my lord. And till date, he's been engaged as an account assistant, my lord, under the establishment of block development officer, that is response number 4, my lord.
All right.
Yes,
Where is the advertisement?
my lord, that is not annexed in the repetition, my lord.
And where is this order of page 14?
Page 14 is the, my lord, the first engagement order, engagement letter, my lord, by the project director. Instead of giving the appointment under response number 2, my lord, as a junior assistant, my lord, he was given, my lord, contractual engagement under response number 3, my lord. So that is his case, my lord. He applied for a post of junior assistant. Then, my lord, although he was selected, but his engagement was made under the project director, rural development, my lord, agency. Now, my lord,
And he is continuing till
He is
today,
continuing.
contractual appointment.
yes, my lord.
Yes, who is there for the?
Lordship, we have not yet filed a affidavit, but going from the records of this case, I have only two submissions. First is basically he was engaged on a contractual basis in the establishment of DRDA, project director DRDA, which is a different establishment from what he is seeking. And secondly, he merely participated in a recruitment test. He has not shown as to whether that particular recruitment process had reached its logical conclusion. Mere participation in the recruitment process itself would not give him a right. He has to show through his own repetition whether that particular post as such is still there or whether somebody has been appointed to that particular post. That he has not shown. He has simply
No,
stated
he has not shown, but you have also not shown anything since last 12 years.
that I agree. That I agree, because otherwise the matter has been listed very few times. That is a problem, Your Lordship. That's why.
So the sword will come equally to both sides, no? We have no problem with the petitioners.
But the problem here is he was appointed on a contractual basis as accounts assistant in the establishment of project director.
But he says he applied pursuant to an advertisement notice.
Yes.
He has, first of all, he has not annexed that advertisement, and that select list also, whether that selection process reaches and mere participation. I am saying this from the records itself because I don't have the records since we have not filed the
Have
affidavit.
you signed any contract?
Yes, well,
Where is it?
There was a status quo
Page
order,
16,
that's
madam.
why he was directed to continue in that.
Page 16,
particular-
madam.
And I've just been told that the establishment of DIDA has been dissolved since 2017, 16.
So
That's
now where
correct.
is he working then?
With another block development officer, madam. That's one number 4. It's not under the idea, I suppose. But in that case, my
We'll
lord,
ask the deputy commissioner to look into it,
my lord. That may
pass
well.
appropriate orders. That's
I'll-
all. Heard
yes.
Mr. R. Chakraborty, learned counsel for the writ petitioner. Also heard Mr. D. Bora, learned government advocate Assam, appearing on behalf of respondent numbers.
Two, I only appear for
Respondent
two.
number 2, Mr. S. Datta.
One and
Learned Standing Council PNRD Assam has appeared for respond numbers 1, 3, and 4.
One, I am not appearing, my lord. One is this ZAD, my lord.
Standing counsel, Mr. B. Gokul is there.
Respond numbers 3 and 4, none has appeared for respond number 1. Full stop. The writ petitioner hearing. Now, as per the case projected in the writ petition, the respond number 2 herein, the respond number 2, that is the Deputy Commissioner, Kachar, had earlier issued an advertisement inviting applications for filling up 25 posts of junior assistants under his establishment, full stop. Pursuant to the said advertisement, the writ petitioner herein had also applied and thereafter on completion and thereafter participated in the selection process, full stop. After completion of the selection process, a select list was published wherein the petitioner's name appeared at serial number 17. Full stop. According to the petitioner, he ought to have been appointed as a junior assistant on regular basis pursuant to the aforesaid selection process. Full stop. However, instead of doing so, the respondent authorities had given contractual appointment to the petitioner in the post of accounts assistant and placed him at the disposal of the respondent number 3 with an assurance that at an appropriate time, his services will be regularized in the post of junior assistant in the establishment of the respondent number 2. Full stop. Mr. Chakravarti submits that the aforesaid recourse had been adopted by the authorities so as to accommodate persons of their choice in the vacant post of junior assistants. Full stop. Therefore, this is a clear case of violation of the terms and conditions of advertisement as well as the principles of natural justice and administrative fair play. Full stop. Next, this writ petition was filed in the year 2011. Full stop. However, even after lapse of more than 12 years, the respondents have not filed any counter affidavit. Full stop. Therefore, although a copy of the advertisement is not available on record, yet due to non-traversal of the facts stated in the writ petition, this court would have to prima facie treat the assertion made by the petitioner to be correct. Full stop. If it is really a fact that the petitioner had participated in a regular process of recruitment to be made to 25 vacant posts of junior assistant and having emerged as successful, he was given contractual appointment in another post, contractual appointment in the post of account assistant, then there can be hardly any doubt about the fact that the rights of the petitioner had been violated in this case. Full stop. However, the facts, the materials available on record is insufficient for this court to arrive at a clear finding on the aforesaid aspect of the matter. Full stop. Therefore, balancing equities and in order to do complete justice in the matter, this writ petition has been disposed of with a direction upon the respondent number 2 to inquire into the matter and ascertain as to whether the writ petitioner had actually taken part in a regular selection process for filling up the 25 vacant posts of junior assistant in the establishment of Deputy Commissioner Kachar, and if so, did he emerge as a successful candidate in the said process? Full stop. If the answer to the aforesaid questions turn out to be in the affirmative, then the respondent number 2 would forthwith take steps for redressal of grievance of the petitioner by regularizing his service in the post of junior assistant. Full stop. If, however, the result of the inquiry turns out to be something else, the said facts would be informed to the petitioner in writing. The aforesaid exercise be carried out as expeditiously as possible, but not later than 6 weeks from the date of receipt of a certified copy of this order. With the above observation, the writ petition stands disposed of. What is the idea about?
Well, this was earlier dismissed for default, then it was again restored. Deeply obliged, my lord.
Supplementary list, top of the list, item 21.
The humble prayer, my lord, if the matter can be taken up tomorrow. I reached back yesterday night, my lord. I had very little time to go through it. It relates to the equivalence of the rank of the post of assistant of executive engineer in the graph to the rank of lieutenant colonel, and whether the respondents were correct in initiating a department proceeding against the petitioner for wearing badges of the rank of lieutenant colonel. There was an earlier round of litigation where the
But
respondents.
this matter was posted today on the request of your judge.
It was taken up yesterday, and I reached back yesterday night around 12:30, my lord. I had very little time to go through the record. I just need to go through some of the facts so that I can place it easily before the court, my lord. Otherwise, taking some length of time going to the earlier judgment passed by this honorable court by Justice Sharma at that point of time, my lord, where they were required to take a certain decision to pass a speaking order on whether the proceeding should go on or not. That order has been challenged in this writ petition. So I have to compare the judgment with the speaking order passed by the respondents. A little time, my lord, tomorrow tomorrow would do, my lord.
Lordship,
Just need to
Lordship,
flag the pages.
that inquiry proceeding already over in the year 2016, Lordship. And thereafter, the petitioner was promoted to the post of superintendent engineer and also subsequently to the post of chief engineer. That final order, Lordship, that disciplinary proceeding which is challenged in this writ petition, Lordship.
Now the petitioner is holding the post of chief engineer.
Chief engineer, but he was punished when he was holding the post of executive engineer non-functional selection grade, which punishment I had brought on record during the pendency of the writ petition, and which has delayed his entire promotional aspects, madam. So now if the entire disciplinary proceeding is culled, because it was
Then
not supposed to be done.
promotion can be given retrospective.
At best, my lord, perhaps a consideration for
Okay.
something notional,
Yeah.
even if it doesn't come up, my lord, even if it doesn't come up, the slur of a, my lord, of a punishment in his career, my lord, even if that goes, is what, my lord, today morning I had a discussion with the petitioner. Even if that part of that displeasure, that censure that was given to him, that goes, my lord, even then he would be to some extent, my lord.
Censure is not a stigma.
My lord, they had delayed everything on the basis of the punishment given to me based on this disciplinary proceeding. If that goes, whatever, where I remain now, I remain. I do not get anything back, but that it was a wrong done to the petitioner. At that stage, it was when they had charged me with adamance. If I can show that it was they who were adamant, even then, my lord, he is reprised.
Egoistic litigations. Censure doesn't, if you would have
But
come
that
to
is
the
what-
court
that is-
at that point of time,
that-
you would have got the
but-
relief.
My lord, we had initiated the writ petition at the time when they had given me the charge sheet. But since there was no stay in the matter, they proceeded with it to give me the punishment. Even when
Punishment
it's-
is what?
My lord, that-
Censure.
censure.
Censure is a minor
My lord,
punishment.
that led to my delay in the promotion. That
You are
is why-
right, but that cannot be remedied now.
My lord, it could be
You,
if
you cannot get a promotion from
I did
another
not,
date.
I agree to that, but
Yeah.
if the censure is wrong, if the censure itself is wrong,
Hmm.
he is vindicated, my lord.
Why
His
do you
and-
say the censure is wrong?
Well, because the disciplinary proceeding could not have been initiated is the stand of the petitioner, because he was wearing the badges of the rank assigned to him by a notification in the Gazette of India.
So therefore, they were factually wrong.
They were factually
How
wrong.
can the writ court give a view on
My
that?
lord, because in the earlier occasion, this honorable court had taken a view.
All right,
Just
yeah,
tomorrow,
judgment
later,
will be passed tomorrow. You don't have a case.
I'll try to
Give
convince
yourself
myself.
some rest. You have been traveling.
I don't-
How can the read code go into factual inquiry?
That factual aspect is on the basis of the gazette notification, if I was wearing the correct
See, the
badge.
point is, that in these matters, the parameters for a read course exercise of jurisdiction is very well laid down. If it is a malafide arbitrary exercise, dehours the rules. If it is the discretion of the authorities on a factual point, even if they are wrong, nothing can be done.
We are not on the discussion part. The simple point is, if
That is, what I'm saying is, we will presume that they were right, and then you have to argue.
done so, my lord, their gazette notification being correct. If I was wearing the badges of that particular rank, then the discipline proceeding would not be there. If I was wearing, if they can show that I was wearing a wrong badge, the discipline proceeding
That's
will
a
not be
question of
interfered.
fact.
But I admit that I was wearing a particular badge. They say that you are wearing this particular badge. Whether the badge is of the particular rank as per the gazette
Is it
notification.
not a disputed question of fact?
It will not be, my lord, because the gazette
All right,
notification says.
take your chance, but you know the
I'll
order.
take a chance tomorrow.
You know the order that is coming tomorrow. These matters cannot be entertained. Just for your satisfaction, I am posting it tomorrow.
Tomorrow, my lord.
Otherwise, these are what is there in it? These are old matters. What is there in it? These are all factual dispute. If you had a remedy to be availed, it could have been at that point of time, but that stage is over now.
That is when
Whether you were wearing a badge or not, we can't go into all
No,
this.
I was wearing a badge. Whether
Or
it is
right
the
badge or
correct
wrong badge, we
But
can't go into all
that will
this.
go through, that will be the gazette notification. They say this is the badge. That is all.
Read code cannot give a finding
I'll
on that.
just want tomorrow, if I can take a chance from tomorrow.
Tomorrow, but you know the order.
I'll
Come prepared for that.
try this.
Factual matters, the read code, it is improper to go into it. These things are creating unnecessary problem. The authorities may be wrong. See, in arbitration, what is the law?
Yeah.
Even if the arbitrator says black as white, even then you can't go into it. The finding of the arbitrator has to be perverse. Materials should show that it is black and the arbitrator must hold that it is white. Then only the court will interfere.
Worship has given me a way out, my lord. I'll show that it is.
That is
black
why I
and
have
they
given
called
you
it
the way.
I'll show that it was black and they called it white. I'll just,
Unless there
restrict
is
myself.
perversity in the issue, read court cannot go into it.
I will restrict myself to only that part.
So if you can show perversity, we'll interfere, otherwise we'll dismiss your petition. Be very clear about it. There's no point laboring on
No,
this.
I will not go into India.
I'll give you 7.5 minutes. 5 minutes to her. Another 10 minutes to dictate the judgment. That's all for a 2011 matter. This case again tomorrow on the request of Mr. Majumdar. Top of the list.
For admission, item 4 to 8.
It's not going to go. May please the lordship. But the state has argued before the lordship about 4 points. Number one, that the cabinet decision was not challenged, therefore it is not maintainable. It is not maintainable. As already to it, they have challenged only the consequential order, and the court cannot go into it. On the factual aspects of the matter, they want to say that the impugned order was passed, so to say, the enhancement of the age of the superannuation of the allopathic doctors was done due to the scarcity of allopathic doctors. So to say, there are plenty of Ayurvedic doctors. In the counter affidavit, in paragraph 3 and 4, referring to 3 and 4 of the counter affidavit. If your lordship takes to 3 and 4 of the counter affidavit, item 5 minorities.
Item?
Item number 5, note 7707. Counter affidavit. At page, paragraph 4 and 5.
Paragraph 4.
Yes.
That the deponent wishes to state that the cadre strength of Ayurvedic doctors under the Health and Family Welfare Department, Government of Assam, is 449. And that breakup is there thereafter. Currently, there are 82 numbers of vacant posts out of the total 449 cadre posts. Further, every year, a total now 93 Ayurvedic doctors, 63 UG and 30 PG graduate from the only Ayurvedic college in the state, Government Ayurvedic College, Guwahati. That apart, there are many other colleges in the country providing BMS degrees, and a huge number of students hailing from the state graduate every year from those colleges, and many of these passed out Ayurvedic doctors aspire to serve under the government. Thus, there is no dearth of Ayurvedic doctors in the state. Then paragraph 5. The rationale behind enhancement of the age of retirement of Ayurvedic doctors and dental surgeons. Your Lordship will remark it, dental surgeons are also there, working under the Health and Family Welfare Department, was the decreasing number of medical officers in the government service. Every year, a large number of doctors graduate from the government medical colleges in the state, presently from the 6 medical colleges of the state. But now it is increased. It is about 9 or 12. 10. The same is not reflected in the recruitment process. For instance, recently, for recruitment of medical and health officer, total number of 576 numbers of posts were advertised, and only 321 posts were filled up. That there is shortage of allopathic doctors and dental surgeons in the state. If senior experienced doctors retire at the age of 60, despite having capacity to continue in service, it will only elevate the shortage, scarcity, which is again not in public interest. Keeping this in view, the Health and Family Welfare Department has decided to enhance the age of retirement of allopathic doctors and dental surgeons from 60 to 65 years so that there is no shortage of doctors in the above categories and adequate healthcare services can be provided. In the next paragraph, last 3 lines, the enhancement of retirement of Ayurvedic doctors from 60 to 65 years will only deprive the fresh graduate from the government employment and serve the state, and thus will affect the aspirations of their own young Ayurvedic doctors. Then the third paragraph, skipping over the first line, be it stated that the enhancement of the retirement age of the allopathic doctors was not based on the nature of duty rather than dearth of medical officers in the service of the state despite having adequate vacancies. That is the one to say. Now, it does not show. They have given a bold statement to show that there are plenty of Ayurvedic doctors and there are less numbers of allopathic doctors or dental surgeons. But the figure, they have not given anything. Comparative chart, if there is no comparative assessment, it cannot be said that there are dearth of medical officers in the allopathic branch. In that case, my lord, we have given a reply to it. Your Lordship can see the reply, our reply. Paragraph 6 of affidavit in reply. It has not been controverted. Paragraph 5 and 6. Although it has been shown 449 numbers are cadre strength of all the posts, all the cadre, but the entry cadre is not there. Entry cadre intake is less. Paragraph 5. That the statements made in paragraph 4 of the affidavit in position are partly admitted and partly denied by the respondent. The deponent begs to state that out of the 93, they are giving us the breakup. Seats of BMS and MD, MS, I would 24 numbers, PG and 15 seats are allocated to the central pool, CGN seat and Northeastern quota. And only 69 Ayurvedic doctors belonging to the state of Assam who pass out yearly from the government Ayurvedic College, Anganwadi. It is only 69 candidates, Ayurvedic doctors, who are entitled to appointment in the entry category. Not the total number, as they say, 93. Next paragraph. As per the Indian Health Standard, IPHS norms, about 1,800 Ayurvedic doctors are required for the state of Assam, out of which Government of Assam Health and Family Welfare Department has created only 449 posts. It is pertinent to mention that as per register of the Assam State Council of Indian Medicine, as on 21, there are 1303 numbers of registered Ayurvedic doctors in the state of Assam, including the BMS doctors passed out every year from other states of India. Then paragraph 6, we have tried to give in a chart of the appointments so far made of the allopathic doctors and Ayurvedic doctors and dental surgeons also.
This one. Where are the decisions? State? No, sir. Yes, yes, please.
Paragraph 6 minutes of the reply.
Yes.
Paragraph 6 of reply. It is stated that the government of Assam filed advertisement. That was the advertisement made in 2020. During the pendency of the writ petition, and a further recruitment was made for the allopathy doctor. That was in 22. We have tried to bring it on record by way of an additional affidavit in reply, while placed before it. 476 numbers of vacant posts were determined. The Medical and Health Recruitment Board had selected 656 numbers of eligible candidates to appear for the interview, which shows that the number of eligible candidates for the post is much more than the number of posts advertised. Because we have no hand in giving your lordship the figure so far as the number of applicants are concerned. Because this is on the website and we got it from the website. Last paragraph of the same page, paragraph 6. Further, the deponent begs to state that the National Health Mission, Assam, while advertisement dated 2019, invited application for filling up of 22 numbers of vacant posts of IUR, MO, for engagement on contractual basis. In response to the same advertisement, candidates who applied were shortlisted to 111 number of candidates for interview for the post of MOIU. This shows the contention of the respondent that there is no scarcity of Ayurvedic doctors in the state is not correct. Then we have given a chart as per page 5 of the reply affidavit, which shows the ratio of number of vacancy and the candidates shortlisted to be more. The ratio is more. That is for the dental surgeon concerned. Of course, it is a bit less than the Ayurvedic doctors, It is a bit less than the Ayurvedic doctors, but in 2022, now the ratio has increased because of the number of the medical colleges that have come. Additional supplementary affidavit in reply, paragraph 3, that with further reference to paragraph 6 of the affidavit of reply, the deponent begs to state that after 2020, a fresh advertisement was made on 21/9/2022, was made for 151 numbers of posts of MO and H1 MBBS doctors. It is the entry grade matter of both the groups. Medical and Health Recruitment Board, while list data so and so, shortlisted 964 eligible candidates to appear for interview, which shows a comparative ratio of 1:6.38. Now the ratio is virtually equal. In case of Ayurvedic doctors, it was last appointed, Assam Health Mission was appointment made. But so far as the state government is concerned, no appointments were made since 2015. 82 numbers of posts are still lying vacant. Therefore, you can't say that there is shortage of allopathy doctors or dental surgeons. Your Lordship needs to see the dental surgeons have also been included. But the ratio of the dental surgeons, it shows that for one post, there are plenty of dental surgeons, 30 applications were made. Sorry, 30 candidates were shortlisted. The chart that I have given to your Lordship at page 5 of the, or paragraph 6 of the affidavit reply. That was also made in 2020. And the chart that we gave is the Assam Health Mission, National Health Mission, not the state government. State government is not, still 82 posts are lying vacant. Further, we have stated that there is a council for all the systems of medicine. The doctors have to register it. Their name. Now, allopathy doctors also get it registered, and we also get it registered. And dental surgeons have also separate council, they can register. If we are quick.
The council is a party here.
No, no. কোথায় ফিগারটা কোথায়? রিডিং এ কোথায় আছে? রিডিং এ কোথায় আছে? আমার কপি দরকার, আমার কপি দরকার, কোর্টকে কপি দরকার। I'm giving a chart, it is in the pleading, but scattered here and there. Therefore, I've carved out the different heading and trying to give a picture. Total contestants 449, 3600 and 130. Number of registered practitioners in the respective state council. 1303 medical officer Ayur, to 24,000 and 3,000. Number of passed out doctors per year. Now it is increased for the MBBS courses. It has become now 1450. and we remain at 48, 49. Dental college is, that is about 40.
Mr. Das, what is the principle? What is the principle on your argument?
Principle is there is no rational criteria. And they want to say that the rational criteria is, whatever it may be, is the scarcity of doctors. I want to show that this fact is not correct on fact as well as on law. There is no factual basis for that, that there is scarcity of allopathy doctors. That is
That's
what.
right, but as we argued the other day, these are in the realm of policy decision of the government.
Yes, I am coming to that. I am coming to that. After that. It is the realm of policy decision, and also, my lord, that it is not maintainable because of the cabinet decision and all that. I am coming to that. The first argument will be that there is scarcity of allopathy doctors, and that is the reason for enhancing the age of only the allopathy doctors or the dental surgeon, and not the Ayurvedic doctors. There are plenty of Ayurvedic doctors. They wanted to give an impression like that, but that is not the correct position. Factually, there is scarcity of Ayurvedic doctors also. In fact, my lord, there are more numbers of doctors, MBBS doctors are coming out from the medical colleges now and the dental institutes. Secondly, that if the object of enhancement of the age is to cater to the needs of the public, so to say, to decrease the ratio of the patient-doctor, doctor-patient ratio, then all the enhancements should be given to everybody. The object is catering to the needs of the public, general public, healthcare system. Healthcare system public is required, and that is why to confine it to the allopathic doctors only is not going to serve the object. Therefore, the two things are for discrimination. Two factors are necessary. Your Lordship knows it, that there should be intelligible differentia, and that differentia must have a rational relation to the object sought to be achieved. Now, even if a Lordship holds that scarcity of scarcity, and scarcity of doctors are there, MBBS doctors are there, then also this has got no relationship.
No, we are not going to hold anything.
Yes.
We will only see if there is some basis for the policy decision.
Yes.
And is it in the realm of policy?
Yes.
Mr. Das, the court cannot go into sufficiency of reason.
Yes.
If a reasonable classification based on intellectual differential is permissible, then of course the court will stay its hands off. And secondly, what is the impact of not challenging the cabinet decision?
Yes.
These are the two aspects
Yes,
of this case. What else is there? What else is there? Whether they are right in their understanding or not, that cannot be a subject matter of judicial review. Whether the decision is arbitrary or not, discriminatory,
Yes.
that we can see.
Yes. First, I am coming to my lord, policy decision. So far as the policy decision is concerned, even if it is a policy decision of the government, they wanted to show, my lord, citing a case law of Nagaland. Nagaland case law.
Yes.
2010 7 SCC 643. By relying upon this case, they wanted to show that it is a government policy so far as fixing a particular day for retirement of employees. It does not say that there is a discrimination. If there is a discrimination between the employees, what will happen? He has referred to my lord paragraph 36, 40, 44, 51, 53, and 57. Your lordship can see 57. Nagaland Senior Government Employees Welfare. 57. Merely because some employees had to retire from public employment on completion of 35 years of service, although they have not completed 55 years of age, does not lead to any conclusion that the impugned enactment is arbitrary, irrational, unfair, or unconstitutional. The fact that the provision such as the impugned provision that allows the retirement from public employment on completion of 35 years of service is not to be found in other states is of no relevance. As a matter of fact, the retirement policy concerning public employment differs from state to state. Kerala retires at the age of 55 years. In any case, there is nothing wrong if the legislation provides for retirement of government employees based on maximum length of service or attaining the age of particular age, whichever is earlier, if the prescribed length of service or age is not irrational. This is, well, along with that, your lordship can see paragraph 53. No.
Yes.
51. Paragraph 51, as the lordship was saying. In our opinion, the legislation of the kind we are concerned with must be regarded as establishing a government policy for retirement of public employment based on age or length of service to achieve a legitimate aim in public interest to permit better access to employment to a large number of educated youth in the state and for the purpose of curbing the unemployment. Legitimacy of such an aim of public interest cannot be reasonably called into question. This is a public policy. This is banked upon by them. Now, if in this case is not an authority for the proposition that if there is a discrimination between the same employees, what will happen? This case refers to a uniform policy for all the employees. Even if it is a policy decision. But if the policy is arbitrary or discriminatory, then your lordship can interfere. There are two decisions I am citing, my lord. 2002, 6, the put to them. Copy the. Although making a policy, my lord, is the domain of the government and supposed to lay their hands off. It is the general principles. But if the policy court has also the justification to look into the policy and come to a finding that the policy is justified. Otherwise, my lord, if it is not justified, then the court can interfere. This one. The 6562. Paragraph 11, my lord. Paragraph 11.
Yes.
First and foremost question that would arise for consideration in this group of appeals is whether the circular data so providing for bonus mark for residents of the district concerned and the rural areas within the district is constitutionally valid, tested on the trustment of Article 14 and 16 of the Constitution of India. It is on this aspect, learned senior counsel appearing for the candidates concerned have argued at length with admirable clarity, making copious reference to several pronouncements of this court. There can be little doubt that the impugned circular is the product of the policy decision taken by the government. Even then, as rightly pointed out by the High Court, such decision has to pass the test of Articles 14 and 16 of the Constitution. If the policy decision, which in the present case has the undoubted effect of deviating from the normal and salutary rule of selection based on merit, is subservient to the doctrine of equality, it cannot sustain. It should be free from the vice of arbitrariness and conform to the well-settled norms, both positive and negative, underlying Articles 14 and 16 together with Article 15 from part of the Constitutional Code of Equality. In this case, my lord, it was held ultimately that the High Court was justified, and because of the policy decision, there is a deviation from the norms of selection. Two 2008-2. Without.
So anything in reply? You want to make any submission on reply?
Already, Advocate General has already.
No reply is required.
On that arguments.
Yes.
It will be 21 to them. Twenty-one 7 SCC. So go to the copy the. Twenty-one 7 SCC 772. Paragraph 15, 18, and 19. Okay.
Yes. So, Mr. Das, you will require some more time.
Now, 15 minutes.
We'll
Yes, yes.
come back up. Yes, please.
I was trying to show, my lord, with the policy decision, the second decision, 2008 volume 2 SCC, I've given a copy to your lordship.
Yes.
2008 volume 2 SCC 672,
Yes.
paragraph 64 and 65. Paragraph 64 at page 697. An executive order termed as a policy decision is not beyond the pale of judicial review, whereas the superior courts may not interfere with the nitty-gritty of the policy or substitute one by the other, but it will not be correct to contend that the court shall lay his judicial hands off when a plea is raised that the impugned decision is a policy decision. Interference therewith on the part of the Superior Court would not be without jurisdiction and is subject to judicial review. Broadly, a policy decision is subject to judicial review on the following grounds: if it is unconstitutional, if it is dehors the provisions of the Act and the regulation, if the delegatee has acted beyond the powers of delegation, if the executive policy is contrary to the statutory or larger policy. Next case is 2021 7 SCC 772. I've given a copy to you, Lord. Paragraph 15, 18, and 19. Paragraph 15. It is right to state that separation of powers is a part of the basic structure of the Constitution. Policy making continues to be in the sole domain of the executive. Judiciary does not possess the authority or competence to assume the role of the executive, which is democratically accountable for its actions and has access to the resources which are instrumental to policy formulation. However, this separation of powers does not result in courts lacking jurisdiction in conducting a judicial review of these policies. Our constitution does not envisage courts to be silent spectators when constitutional rights of citizens are infringed by executive policy. Judicial review and soliciting constitutional justification for policies formulated by the executive is an essential function which the courts are entrusted to perform. Then paragraph 18. Similarly, the courts across the globe have responded to constitutional challenges to executive policies that have directly or indirectly violated rights and liberties of the citizens. Courts have often reiterated the expertise of the executive in managing the public health crisis, but have also warned against arbitrary and irrational policies being executed in the garb of wide latitude to the executive that is necessitated to battle a pandemic. This was in the nature of the, in the context of the pandemic that engulfed us. Then paragraph 19. In grappling with the second wave of the pandemic, this court does not intend to second guess the wisdom of the executive when it chooses between two competing and efficacious policy measures. However, it continues to exercise jurisdiction to determine if the chosen policy measure conforms to the standards of reasonableness or militates against manifest arbitrariness or protects the right to life of all the persons. Simply saying that it is a policy decision, but the policy decision, if it is arbitrary, if it is discriminatory, there is no rational criteria for distinction, and the object of the policy is not going to be served because of the discrimination, then this court can interfere. That is my humble submission before Lordship. The next case, my Lord, about the question that it was raised that cabinet decision was not challenged. Cabinet decision was not challenged, and therefore the writ petition would not be maintainable. And as a corollary to that one, they have only challenged the consequential order, praying for a writ of mandamus to equate them with the allopathic doctors. This is not maintainable. Now, in that respect, my Lord, if I may submit that the cabinet decision is, after all, a decision of the Council of Ministers. That has to be implemented through a government order. Otherwise, the cabinet decision has got no value at all. Cabinet decision may be changed. Under 166, all the executive actions of the 166 of the Constitution of India, all the executive actions of the government.
166 of rules of executive business.
Under the rules of executive business. Under 166 also. Under 166 provides for rules of business. Under the rules of business, under 166 of the Constitution of India, the Council of Ministers are only advisors to the governor. Unless it is implemented in the name of the governor or expressed in the name of the governor, it is not liable to be challenged, nor it affords an right to the person concerned to enforce it by writ petition. In that respect, my Lord, if I may please before Lordship, 1963 Supreme Court 395. Paragraph 9 and 10. In this case, the petitioner wanted to enforce a cabinet decision, sorry, sir, not a cabinet decision, a decision given in the file by the minister concerned. Paragraph 9 and 10. The question therefore is whether he did in fact make such an order. He means the minister concerned, revenue minister. Merely writing something on the file does not amount to an order. Before something amounts to an order of the state government, two things are necessary. The order has to be expressed in the name of the governor as required by Article Clause 1 of Article 166, and then it is to be communicated. As already indicated, no formal order modifying the decision of the Revenue Secretary was ever made. Until such an order is drawn up, the state government cannot, in our opinion, be regarded as bound by what was stated in the file. As long as the matters rested with him, the revenue minister could well score out his remarks or minutes from the file and write fresh ones. Number 10, the business of the state is a complicated one and is necessary to be conducted through the agency of a large number of officials and authorities. The Constitution therefore requires, and so did rules of business framed by the Raj Pramukh of PSU, provide that the action must be taken by the authority concerned in the name of the Raj Pramukh. At that time, it was the Raj Pramukh, my lord, because before the state reorganization before 1956. Part B states, it is not till this formality is observed that the action can be regarded as that of the state or here by the Raj Pramukh. We may further observe that constitutionally speaking, the minister is no more than an advisor, and that the head of the state, the governor or Raj Pramukh, is to act with the aid and advice of the council of ministers. Therefore, until such advice is accepted by the governor, whatever the minister or the council of ministers may say in regard to the particular matter does not become an action of the state until the advice of the council of ministers is accepted or deemed to be accepted by the head of the state. Then next case, 2086, sorry, 86 4 STC 632, paragraph 41. In that case, there was a decision of the Council of Ministers, and the petitioners, they wanted to bank up on that decision. But subsequently, that decision was changed by another cabinet decision. That in that context, my lord, the paragraph 44, you put that. Paragraph 41. State of Kerala versus Recruitment, paragraph 41. There was quite some discussions at the bar as to whether the Council of Ministers would have reviewed their earlier, paragraph 41, you got it?
Yes.
Reviewed their earlier decision and decided not to appoint anybody from the panel of names forwarded by the High Court and to issue a fresh notification inviting application. The answer to the question is self-evident. Merely because the Chief Minister briefed the press on 31st January as regards the decision taken at the meeting of the Council of Ministers held on the previous day, the news of the press conference having published in Matribhumi and other Malayalam newspapers to the effect that the government has decided to fill up the 4 posts of district judges, it could not be said that there was an order of the state government in the manner required by Article 166(1). What the news item conveyed was that the Council of Registers had taken a decision to advise the governor to appoint so-and-so. The governor has to act with the aid and advice of the Council of Ministers under Article 163(1). Whatever the Council of Ministers say in regard to a particular matter does not become action of the state government. Till the advice of the Council of Ministers is accepted or deemed to be accepted by the head of the state, before an advice of the Council of Ministers amount in order of the government, two requirements are there. Order has to be expressed and this is to be communicated. There is a direct case on the question while the petitioners wanted to enforce a cabinet decision in 2003 5 SCC 134. 2003 5 SCC 134. Copy that. In paragraph 2, your lordship, in the placenta in between F and G, at page 140, in between F and G, the writ application was filed before the Rajasthan High Court at Jaipur bench. The stand of the appellant before the learned single judge was that there was a cabinet decision taken to release salary to the appellant for the balance period, which was to be paid. That was his argument. He wanted to bank upon that decision of the cabinet. Paragraph 3, first 3 lines. Learned counsel for the appellant primarily took 3 stands in support of the appeal. Paragraph 3. Firstly, it was submitted that the decision of the cabinet was enforceable. In that context, my lord, paragraph 7 and paragraph 8. Paragraph 7, after quotation 166, a lordship may please see, and paragraph 8. Let's sit down. Paragraph 7, paragraph 8. Therefore, we have not challenged the cabinet decision. Otherwise, also, we are seeking a parity because the cabinet decision was communicated in the name of the governor by a notification. Page 30. Annexure 8. 36. Page 36 of the Recruitment 7707. In pursuance of the cabinet decision, the governor of Assam is pleased to raise the age of superannuation of retirement of allopathy doctors or cadets so and so. We want a parity with this one. If We have not challenged it because if it goes, it robs us of our right. Our right accrues from this one in the sense that this is under inclusive. We are also in the same birds of the same feather, but we are excluded. In that respect, my lord, may I submit, my lord, that the discrimination is of two types. One is under-inclusive, one is over, the other is over-inclusive. Under-inclusive is one where the similar persons have not been grouped together. Some persons have some kind, or a group, although similar, have been excluded. The other case of over-inclusiveness is that although the other group is not similar, it is the question of similarity, not the identity. Or not similar, but they have been grouped together. In that case, the agreed persons, supposing it is under-inclusive, my case is about under-inclusiveness, because we have been left out. The relief that we can claim is extend the benefit to us also by a merit of mandamus, because that has been given to a certain sections of the group or a particular group. Otherwise, it is discriminatory. In that respect, my lord, may I place before your lordship a particular judgment of the Constitutional Bench judgment of the Honorable Court, 74-4 SCC 656. Paragraph 53, 54, 55. 53, no? Okay. Paragraph 53. The equal protection of the law is the place to the protection of equal laws, but laws may classify, and the very idea of classification is that of inequality. In tackling this paradox, the court has neither abandoned the demand for equality nor denied the legislative right to classify. It has taken a middle course. It has resolved the contradictory demands of legislative specialization and constitutional generality by a doctrine of reasonable classification. Then paragraph 54. A reasonable classification is one which includes all who are similarly situated and none who are not. The question then is, what does this phrase similarly situated mean? The answer to the question is that we must look for beyond the classification for the purpose of the law. A reasonable classification is one which includes all persons who are similarly situated with respect to the purpose of the law. The purpose of the law may be either the elimination of a public mischief or the achievement of some positive public good. Then 55. A classification is under-inclusive when all who are included in the class are tainted with the same mischief, but there are others also tainted whom the classification does not include. In other words, a classification is bad as under-inclusive when a state benefits or burdens persons in a manner that furthers a legitimate purpose, but does not confer the same benefit or place the same burden on others who are similarly situated. A classification is over-inclusive when it concludes that not only those who are similarly situated with respect to the purpose, but others who are not situated as well. In other words, this type of classification imposes a burden upon a wider range of individuals than are included in the class of those attended with the mischief at which aim law. Herod ordering the death of all male children born on a particular day because one of them would someday bring about his downfall employed such a classification. Then paragraph 76, last paragraph. What can be the relief that can be claimed? Last paragraph, paragraph 76. Whether a court can remove the unreasonableness of a classification when it is under-inclusive by extending the ambit of legislation to cover the class omitted to be included, or by applying the doctrine of severability, delete a clause which makes a classification over-inclusive, are matters on which it is not necessary to express any final opinion, as we have held that the inclusion of the tramways and motor omnibus service in the definition of establishment did not make any classification as not unreasonable. Herein, the discrimination was held to be justified. Therefore, the court did not grant any relief. But in case of it has been indicated here that in case of under-inclusiveness, the court may grant the relief of extending the benefit. But whether it will be given or not, it depends on the court. But in this case, it is not necessary because we have held that discrimination was justified. No. In regard to the cabinet decision, my lord, the state banked upon a decision of your lordship at 2018 3 GLT 44.
Yes.
কত paragraph?
Yes.
27, 28. That was a case, my lord, wherein only the professors of an university were given the enhancement of age, and the assistant professor or the associate professor are not granted. In terms of the commission's report, university report, recommendation by the UGC, it was held otherwise that it was only a recommendation of the UGC. The state government may give it, may not give it. There was no discrimination as such. In that context, it seems, my lord, that a supreme decision of a Supreme Court in 2011, Haryana, state of Himachal Pradesh versus 2000 was it was based on that decision. Certain observations in that decision. Paragraph 18 of that case is put it here. Your Lordship held that petitioners had not challenged the cabinet decision. And that was based on paragraph 18 of a Supreme Court judgment. In the Supreme Court judgment, what happened? The division bench of the High Court, in between the interregnum of completion of the hearing and delivery of the judgment, the earlier cabinet decision was reviewed. That was set aside. In that context, it was held that neither the cabinet, that cabinet decision was an issue or raised before the court. Therefore, High Court committed an error. This does not lay down a principle as such of universal application. The cabinet decision confers some sort of a right or liability. It confers some sort of a right or liability only when it is expressed in the name of the governor. All right. And that judgment of single bench judgment of 2018 GLT 44, it was taken in appeal. In appeal, my lord, the question of discrimination was looked into. And it was held that it was not discriminatory. Now that judgment is operating in the field. And by virtue of the doctrine of merger, so to say, that was in writ appeal number 251. The other side is given a copy of it. But I'm also giving you 2,200 writ appeal only Thomas Shaikian. It was held that the associate professor or assistant professors are not similar to the professors. And it rested at that. The question of cabinet decision and all that is not gone into therein. Therefore, this is by the doctrine of merger, this is the decision which is holding the field.
Which is the decision?
This is the writ appeal decision. The writ appeal decision is holding the field.
Correct. So what does it mean? This decision is gone. Single judge is this 2018 3GLT is gone.
No, 2018 GLT, I say, I beg to submit that it is based on a Supreme Court judgment, paragraph 18. But that judgment was given in the context that was not applicable. That in between the conclusion of hearing and the delivery of the judgment, the earlier cabinet decision was reviewed and changed. That was set aside by the division bench of the High Court in 2011 STC. In that context, it was said that the cabinet decision was neither challenged nor it was at issue. Therefore, it could not have been set aside. In that context.
Yes, that's all.
Oh, well, there is another judgment which is standing in our way. The latest judgment of the Supreme Court. That is state of Gujarat versus PA Bhatt. Copy I was given to you the other side.
Where it has been held that the Ayurvedic doctors are different.
And different in the sense that they do not do complicated surgery.
So therefore, there is this Supreme Court judgment.
No, but this judgment is distinguishable on fact. I am giving 4 reasons of the distinguishing. Number one, your lordship will be pleased to see paragraph 20. In that case, Dr. North Delhi Municipal Corporation, Dr. Ramnara Sharma was placed into service. And paragraph 20, what it said? In this case, the question revolved around the question whether the Ayurvedic doctors would be allowed the same pay scale. It was a Gujarat specific case. In our case, it is not. Our case, the same pay scale is there. The same entry grade. Same pay scale, same duty. But therein the government of Gujarat gave an affidavit showing the difference that they do not perform the same duty. Paragraph 20, your lordship, please
If the
to see.
state now follows these and changes the pay scale, then what happens?
Huh?
If the state of Assam now follows this judgment
Huh.
and makes a difference in the pay scale of Ayurvedic and allopathic doctors, then there will be more difficulty.
Yes. Because of the nature of the work, the state government has filed an affidavit therein, showing that the nature of the work of the Ayurvedic doctors and the allopathic doctors are different. But in paragraph 20 of my writ petition, I have stated, I have given a chart that OPD, IPD, all these things, and National Health Mission, all these works we have to do. And they have not to do. There is no difference in the work chart. And moreover, your lordship, please to see, it is being extension of the benefit has been given to the dental surgeons also. But the dental surgeons, by paragraph 20 of the writ petition, madam. Just have a look. Writ petition.
Party rules.
Paragraph 20 of the writ petition.
Yes.
Down below, service status. Pay scale same, entry same, nature of duty, OPD, IPD, surgery, emergency, night duty, delivery conduct, National Health Program. OPD, IPD, surgery, emergency, night duty, delivery conduct, National Health Program. And so the dental surgeons are concerned, only OPD duty. And the rural incentive is provided to us also, to the allopathy doctors also. But in the Supreme Court case, state government gave an affidavit showing that is reflected in paragraph 41 and 43 of the judgment. 41 and 43 of the judgment. That they do, Ayurvedic doctors don't do the OPD duty or IPD duty. Paragraph 41 and 43 of the judgment. Paragraph 41.
Yes.
Required to perform, number 2, required to perform emergency duties, trauma duties, surgery cases and post-mortem cases. No emergency duty cannot perform surgery and post-mortem. We do the emergency duty also. Have to work in OPD and operation theatre. No operation work.
So what is the surgery done by Ayurvedic doctor? He can do a heart surgery. Or
Yes. It was originally not there. But now in 2016, by virtue of an amendment in the council curriculum, 39 general complicated surgery have been included for the postgraduate one. Specialized treatment. I have annexed it, my lord.
Is it correct that Ayurvedic doctors are doing surgery, IPD duty and surgery?
In their own way, own system, in their own system.
What is that?
Chedon, Rechon, but it may not be similar to this one.
No, but what is that system?
Huh?
What is that system?
Ayurvedic system,
No anesthesia, nothing.
anesthesia is there, the
Then-
same thing. কোথায়? দাঁড়ান, এটা কোথায় দিছো? Copy দিলাম। It is called Shalva Chikitsa. In 2020, it has these are the 39 procedures. Your Lordship can look to my lord, item number 13. Bhagandar Chedan, Khara Sutra, fistula to be and fistula out of it. Fistula, my lord, they can do it in their own way. The Ayurvedic doctors also do it. But PG, one has to be PG degree holder. Here also MBBS doctor do not do any surgery. It is the MS who does the surgery. Ayurvedic also, my lord, the MS degree is there, MS Ayur, MD Ayur. And the page 7.
No, that is understood. Here the question is not whether they deserve this or they deserve that. That's not the question. The question with which the court will be
Yes.
concerned is whether the decision of the government not to extend the age of Ayurvedic doctors being a policy decision, does it tend to discriminate one class of equally placed doctors, thereby violating their constitutional right? Or is it a case where there is a justifiable basis to make a reasonable classification?
Yes.
That's the only question that will be answered by the court, nothing else.
Yes.
We don't know whether Ayurvedic is this or that. So the justification given by the government is not on their qualification or their
No, Supreme Court judgment.
Supreme Court judgment may be there,
But
but in this case, the government stand is, we don't need so many doctors in Ayurvedic. So therefore, if we increase their education,
they don't say we don't need. They say there are plenty of Ayurvedic.
that's it,
Plenty
same
of-
thing,
Plenty.
same thing. So
Plenty
if
of
we
Ayurvedic
increase their retirement
Therefore,
age,
they are educated number of Ayurvedic doctors.
will not get employment. That's their plea.
That's-
That's all. So we'll not go into sufficiency, but
No,
Let's see
I'm
whether
not,
the-
I'm not going. I'm not going into sufficient, but the Supreme Court judgment as such
Hmm.
is not applicable in our case. Because paragraph 20, it is stated that Ramnaresh, the earlier case law, that your lordship has seen,
Hmm.
not the municipal corporation case, paragraph 18 and 19.
yes,
That case, issues are different. And herein the issues are different. And paragraph 41, 43 is the nature of job. And in that context, it was held that the Ayurvedic doctors do not perform the complicated surgery. Paragraph 48, 44, 49. And your lordship, please to see paragraph 49. Therefore, we have no doubt that every alternative system of medicine may have its pride of place in the history. But today, the practitioners of indigenous systems of medicine do not perform complicated surgery or surgical operations. A study of Ayurveda does not authorize them to perform this surgery. Possibly, my lord, the adequate material was not placed before the Supreme Court. The legislation of 2020 was not placed before the Supreme Court. Because our MS doctors, they do complicated surgery also in their own way. Not in their surgery will not be different. They say it is Chedan, Kortan.
All right, but in this case, we are not going into all those aspects.
But what I'm trying to argue upon your lordship, that the latest Supreme Court decision is distinguishable on facts of the case. It is Gujarat specific, not of universal application. Gujarat specific. Case. There was. Not easy to.
Let us read this judgment once the Supreme Court
Yes.
latest judgment. Which are the relevant paragraphs?
ওরা কত দেখাইছি না গুজরাট চেষ্টা কত কত দেখাইছিল না না রেজিস্টার টু গুড চেষ্টা আরে না রেজিস্টার কত প্যারাগ্রাফ দেখাইছিল $37 and $54. They placed 37 and 54.
37 and 54.
They're placed.
Yes, let us read what is.
Therefore, it is clear 37.
Yes.
Their classification based upon educational qualification is not violative of Article 14 and 16 of the Constitution. Hence, our answer to issue number 1 will be in the favor of the state and against the respondents. And then oh, sorry, 37 and 54. State of Gujarat, 37 and 54. There is 37 and 54.
Hmm.
Therefore, even while recognizing the importance of the Ayurvedic doctor and the need to promote alternative indigenous systems of medicine, we cannot be oblivious of the fact that both categories of doctors are certainly not performing equal work to be entitled to equal pay.
How can you say this is specific to Gujarat?
Because of this affidavit of the state government, but they don't know to equal work. Therefore, there should be no any parity of pay scale.
No, but the Supreme Court says they are not performing the same work.
Same work because of the affidavit by the Gujarat government, paragraph 41 of the judgment. Paragraph 41 of the judgment that has been quoted. Paragraph 40 also your Lordship can see. The government filed an affidavit before the High Court containing interest. The allopathy doctors are appointed in class 1 post. Allopathy doctors class 2 post. Homeopathy doctors in class 3 post. But we are appointed in as medical health officer number 1. Same post. And then paragraph 9, paragraph 41, in paragraph 9 of the affidavit filed on so and so on behalf of the government before the division bench of the High Court, a comparative chart was provided. It reads as follows. Have to work in OPD and no operation work.
So
Required to
let us,
perform
let us read from para 38 of the judgment. Everything will be clear.
38.
Yes.
Second question arising for consideration as to whether the holders of the degrees and postgraduate degrees in indigenous and other non-allopathic systems of medicine can be said to be performing equal work as the holders of degrees and postgraduate degrees in allopathic system of medicine so as to be entitled to equal pay. In the writ petition filed by them, it was claimed by the respondents herein that they were doing the same work as was done by the other medical officers holding MBBS degrees, and that they were serving in various primary health centers, community health centers. They also claimed that even as per the job chart of the general duty medical officer, the duties are performed by both of doctors are the same. The respondent further claimed that they held posts interchangeable with those of the MBBS degree. The government filed an affidavit before the High Court contending that while the general hospitals and government hospitals come under the medical services department, PHCs, CHCs, and government dispensaries come under the public health department. That in respect to the medical services, doctors with MD, MS, or postgraduate degree, diploma are appointed class 1 specialist cadre. Homeopathy doctors are appointed in class 2 post. Ayurvedic doctors are appointed in class 2 posts. There is a lot of difference between the duties and responsibilities discharged by both these categories of doctors. Then paragraph 41. In paragraph 9 of the affidavit filed by so-and-so on behalf of the government before the revision bench of the High Court, a comparative chart was provided. It reads as follows. First, number 1 is about the degrees. Number 2, required to perform emergency duties, trauma cases, surgery cases, post-mortem cases. No emergency duty, cannot perform surgery and post-mortem. Post-mortem, of course, my lord, it is CRPC, it is already there. Because of the CRPC, that it is to be done by a civil surgeon. And the civil surgeon is invariably from the MBBS, have to work in the OPD and operation theater, no operation work. But we do our operation, our MS doctor in the different institutions of the public health service, public health center, community health center, where infrastructures are available. They do perform the surgeries. Medicines given are number 5. Medicines given are allopathic, such as painkillers. The medicine is based on Ayurveda for etc. powder to be taken with boiled water. There is a difference. So far the diagnosis part is concerned, it is same thing. If you go to the Ayurvedic doctor, they will call for the pathology report, CT scan report, and all these reports or the instruments.
I was just wondering, how will the bar take it if tomorrow we replace the High Court medical officer with an Ayurvedic doctor?
Yes, it can be done. I have been taking treatment. It is the same thing. So far the diagnosis part is concerned. But the medicinal part, medicine is, they say it is of composition is not synthetically done, it is from the vegetables.
They say it is from powder taken with boiled water.
Not necessarily. I am taking the medicine. It is in the tablet form.
That's good. That's good. No, see, there's nothing taking away from the Ayurvedic doctors. They do perform a very important function. And there are large number of.
In fact, my lord, your lordship has heard about Susuto, about Shala Chikitsha. And
Yes.
yes, sir.
No,
He is the father of surgery.
Undoubtedly. Undoubtedly, but every case will have to be decided on the facts which are before the court. So anyways, these are your arguments.
These are my arguments.
So anything?
And clause 6, serial number 6 of that same paragraph. Main duty is with respect to emergencies, casualty, OPD patients. Main duty is to advertise, make people aware about Ayurvedic treatment and all that. That's why I beg to submit. That is the Gujarat specific. So for our country, this goes against, my lord, the contention raised in paragraph 20 of the writ petition. In that context, it was said.
All right. So anything else?
My lord, lastly, my lord, the original case, New Delhi Municipal Corporation, Ram Naresh, that judgment, paragraph 18 and 19.
Yes.
Your lordship has got a copy. কোথায়?
Paragraphs?
Okay. 22 and 23. Why do I? Yes, there you go. Paragraph 22 takes note of the distinction and says that this is not a differential, intelligible differential. And these judgments has been kept untouched in paragraph 20 of the latest judgment.
Was this, this was considered by the.
Yes. Paragraph 20. In the first few paragraphs actually virtually on that judgment. Because the petitioner depended upon that judgment for equality of their pay scale. Paragraph 20 it says, my lord, of the latest judgment.
All right.
Domination somehow in paragraph 20 has been kept untouched. That will apply so far as their decision.
All right.
Yes.
But so far, in the meantime, some of the persons have got retired. Therefore, I placed on judgment of the Rajasthan High Court that if benefit if given may be also given to the persons who have retired. Because there is an observation from of a division bench of this court in a writ appeal against an interim order. We got an interim order, but against that there was a writ appeal and judgment. And there is an observation. How could you do that? Last paragraph, that's page 4. Ultimately succeed in the writ petition if the respondent, who are the writ petitioners, if they succeed in the writ petition, in any event, they would be entitled to the service benefit. On the other hand, if they are allowed, therefore, keeping in view the above expectancy, we are of the opinion that the observation of the only single judge directing the appellant hearing to continue those writ petitions beyond the age of supervision would not be justified.
Which para?
Paragraph, last paragraph. Having taken note of this order, wherein, because it was passed, because a similar order was made earlier in a writ petition.
Yes. You're right. Hard arguments advanced by learned counsel appearing from both the sides. Arguments concluded, judgment. Order will pass. Lead case will be 7707. So you have to organize these things, huh?
But I have given a copy of the written argument that I have made.
It is there.
Yes.
Would you want to give a supplementary argument?
No. It appears there is a lot of papers in the file. But
We are used to it.
right now I have given to your worship.
Unless you want to go paperless. Yes.
Much obliged. I am deeply obliged to your lordship.
What about the expanding method? I can do.
Ready?
My lord, if your lordship permits me, my lord, I'd like to, my lord, your lordships, draw your lordship's attention. my lord,
You get another 1 hour. At 2.
At 2.
Because it's
Lord,
just 5 minutes. to
Can
go.
it be on Thursday, my lord? I'll come prepared, my lord, because yesterday
Your
just I got it,
preparation
my
is
lord.
already very good. You get.
My lord, in this case, my lord, the petitioner is superseded, my lord, in the matter of, my lord, promotion. My lord, his junior admittedly, his junior has been promoted from the extra writer to LDA, thereafter LDA to UDA, but the case of the petitioner has not been considered. My lord, your lordship kindly see, my lord, your lordship wanted to know, my lord, the date of joining of the petitioner, my lord. For that, my lord, I would like to draw your lordship's attention, my lord, at page 55. My lord, this is the seniority list. My lord, serial number 10, your lordship will find, my lord, the name of the petitioner, Vikas Ranjan Som. My lord, then date of birth, education, my lord, date of joining. 1/6/1976. Then my lord, date of regularization, 1/8/1988. And the next page, my lord, respondent number 5, serial number 15. Date of joining, my lord, 27/6. Has your lordship got it, my lord? 27/6/1977 and my lord, regularization 1/9/1992. And my lord, the petitioner, admittedly, my lord, is the senior to the respondent number 5. My service was regularized in the year 1988. His service was regularized, my lord, in the year 1992. I joined in the service in the year 1976. My lord, he joined in 1977. And by annexure 6, 7, and 8, my lord, the petitioner has been, my lord, absorbed, my lord, in the cadre post of LD assistant. Your lordship will find, my lord. If your lordship come back to page 27, annexure 5, my lord. The service of the respondent number 5 has been regularized to the post of, my lord, extra writer. With effect from 1/9/1992. Then, my lord, his name appear, your lordship will find at page 30, Abdul Motin, serial number 56. Then, my lord, by the annexure 6, my lord. He has been, my lord, absorbed in the post of, my lord, LDA.
So both of them have retired from service. True, Miller. What do you want now?
My lord, my lord, the notional benefit, my lord, which, my lord, as per law, my lord, as per the judgment of the Supreme Court.
Notional benefit on what?
Oh, my lord, on pensionary benefit, my lord, with respect of the, if, my lord, if your lordship hold that, my lord, I have been in service, my lord, and I have been promoted in due course of time, my lord. I would have, my lord, get a different scale of pay, my lord. In that case, my
Promoted to which post?
my lord, from extra writer to LDA, LDA to UDA,
No, you retired as what?
as LDA.
Now you want
Annexure
promotion to
16,
UDA.
My lord,
You retired in 2015.
2015.
Today you want promotion to UDA.
No, my lord, I want, my lord, that my pension is a benefit, my lord, which I am entitled, my lord, as per law, my lord. That is what, my lord, notional benefit and notional promotion.
It
your
cannot be.
lordship. My lord, your lordship kindly consider, my lord, we rely upon some judgments, my lord. If your lordship kindly see, my lord. It is like, yeah. No, these are the judgment I am banking on, my lord. My lord, 2014-15 SCC 553. Last paragraph, my lord. Paragraph number 10. May I read, my lord? In the aforesaid circumstances, in our considered view, the tribunal and the High Court erred in law as well as on facts in denying the relief of the appellant. The position would
Mr.
have been.
Sen, you take your time, but the reason why I'll dismiss your writ petition is
My lord,
your two prayers cannot be granted and there is no third prayer. I'm informing you that. You can argue for the rest of the day. It's up to you. The two prayers in the writ petition, one is to set aside the promotion given to private respondent.
that I am not, my lord, pressing, my lord. I am on.
You cannot.
On B, my lord.
What do you mean by I am not? You cannot.
My lord.
The petition has become infructuous.
My.
You are arguing an infructuous petition because you are entitled to, you argue. I am bound to hear you, but your petition has become infructuous.
My lord, I am.
A very seasoned lawyer would have said, this has become infructuous, let's close it. You are just consuming the time of the court. You are showing judgment, citing judgment. You want a lengthy judgment, I'll do it. Rest of the day, I'll hear this matter only.
I'll take, my lord, 5 minutes, my lord, not more than that, my lord. My lord, your lordship, kindly only, my lord, record this judgment, my lord, that's all, my lord.
All right.
I have no problem.
All right, please.
My lord, these
Yes.
are the
Para
judgment.
10, you want to rely para 10?
Para 10.
Yes, please read.
In the circumstances, in our considered view, the tribunal and the High Court erred in law as well as on facts denying relief of the appellant. The position would have been different if appellant junior have been promoted from a date subsequent to his superannuation. Then the appellant would have been suffered only on account of the passage of time or innocuous delay, but in the present facts, he has suffered hostile and arbitrary discrimination vis-a-vis junior. The order appeal is therefore set aside. Since the appellant was in service only till July, till 31st/3/1998 is held to be entitled to notional promotion to the post of the Deputy Superintendent of Police with effect from 29/5/1997 till 31st/3/1999. He will have been have deemed to have superannuated on that post and shall have been given all the post retirement benefits by the recalculating the same on the premise that he held that post of Deputy Superintendent of Police from 29/5/1997 till his superannuation on 31st/3/1998. The revised pensionary benefit as well as the areas on that count should be made available to the appellant at the earliest and in any case within 3 months from the date of this order. The appellant is held consolidated cost of rupees so being paid and other benefits to the time the appeal is allowed. Well, this is one. Another judgment.
No, what is this? This was done in that fact. What is the fact of that case? How is it connected with your case?
My lord,
You have to tell the court all these
it
things.
is not identical, but my lord, in that case, my lord, his notional promotions, my lord, and notional benefits, my lord, were given to the
So
appellant.
place it, what is the fact of that case? Place it before the court.
My lord,
We are not going to go and read the judgment. Whatever you, I'm dictating the order here.
my lord.
You show how is it relevant in your case. You have to argue that.
If I read, my lord, it will take, my lord, more time, my lord. That's
And
what
then
I'm
otherwise,
saying,
who will
my lord.
read it?
My
Who will
lord.
read it? If you don't read, then why should I read
Lord,
it?
I'm reading the relevant parameter. I'm just reading, otherwise, my lord, it will time consuming, my lord, your lordship.
No. If you want to rely on a judgment,
My lord,
you have to rely on the ratio of the judgment. Is it not?
my lord.
So how is that ratio applicable in your case? You have to tell the court.
And I am also paying for notional benefit, notional, my lord.
Notional benefit
in the sense, my lord, that my lord, I was, had my case been considered, my lord, then my lord, I would have retired as a UDA, my lord, I would have get the retirement after retirement benefits, my lord. So that is my.
But you did not come to the court with that prayer.
But I
Your
have filed
case
my
should be considered.
representation, my lord, way back in the year 2006, my lord. My representation, your lordship, kindly consider, my
What
lord.
is the impugned order 29/1/2011? Where is it?
Twenty-ninth of 11, my lord, by this order, my
Where
lord,
is
the
annexure
respondent,
15?
respondent number 5 has been promoted to UDA from LDA to UDA. Overlooking, my lord, the case of the petitioner.
So how that can be set aside today? He is already retired.
But my lord, your lordship kindly consider, my lord, my lord, we have filed representation, my lord, way back in the year 2006.
Where is this order dated 29/1/2011, page number? Which page is this?
Annexure.
Do you know which page is this? The impugned order in the writ petition?
My lord, in my
Page
affidavit,
58,
my
my
lord.
lord.
Huh?
Page 57,
Page 57.
annexure 15. They all are junior to me, my lord. Abdul Mateen, respondent number 5, then Deepak Das, Sandeep Bhattacharya.
So your prayer is to absorb you in
My
the
prayer
LDA.
is, I am on paragraph B, my lord. Your lordship kindly see. A writ in the nature of mandamus shall not be issued directing the respondent authorities to provide for absorption of the petitioner to the cadre post of LD assistant with effect from 1/8/1988 from the date of the service of the petitioner was regularized as extra writer in the department and with consequential promotion of the petitioner to the post of UD assistant in the department with all consequential.
Your
service
client was
benefits.
promoted as LDA when?
LDA Millard, annexure 16 Millard, page 58.
Same date. 29/1/2011. He was promoted to the LDA and I was promoted to the UDM. But what happened, my lord,
But
my
he is
sal-
junior to me, Millard, admittedly. And I was, Millard, on 29th January 2011, Millard. Much after the petitioner, my lord, the respondent number 5 has been, my lord, absorbed and promoted to the post of LDA and UDA, my lord.
Yes, please. What else?
My lord, 2012, 13 SCC 94 Millers. Paragraph 52 Miller. We therefore partly allow the writ petition. We reject the submission of Mr. Challa that suspension of the petitioner was rendered wholly unjustified upon acquittal by the trial court. We also reject the submission of Mr. Challa that the suspension of the petitioner was wholly unjustified during the pendency of the appeal before the High Court. We, however, hold that the continued suspension of the petitioner during the pendency of the departmental proceeding was wholly unjustified. The petitioner is therefore entitled to fully pay and allowances from 27/9/2005, that is the date of the judgment rendered by the Delhi High Court onwards. We further hold that the petitioner was entitled to be considered for promotion notionally from the date when an officer junior to him was promoted. We therefore direct the High Court to consider the case of the petitioner for promotion if otherwise satisfies the requirement as per the rules from the date when the person of the junior to him was considered and promoted to the next higher post, such as a decision to be taken by the High Court within a period of 3 months from the date of the receipt of this order. A2. 1992 submit 2 SCC 172. It's a very short judgment. The complaint of the appellant is that they are still not promoted to the higher post, although their juniors have been promoted as early as May 1983. Promotion to the higher post is governed by the rules of seniority. The appellants had not been considered for promotion. The tribunal found that the appellants were too late in initiating their grievances. It was solely on the basis of delay that the tribunal did not enter into the merits of the appellant's complaint. It is not disputed that the juniors of the appellants had been promoted. However, respondents' counsel submit that the juniors were promoted for justifiable reason. Whatever may be the reasons which promoted the respondent to promote the juniors in preference to the appellants, the fact is that the appellant had a genuine grievance insofar as they had been superseded by the juniors. This is precisely the dispute which the tribunal ought to have considered, but unfortunately it did not do so, the reason of delay. Having heard counsel both sides and perused the records, we are of the view that despite delay, the matter requires reinvestigation. Accordingly, we direct the tribunal to rehear the parties, giving an opportunity to impeach the necessary parties, file a fresh affidavit and reduce any other evidence which may be wished to abuse. This is my lord, and the last judgment, my lord, I will rely. One seven. My lord, 2013-12 SCC 171. Para 17, my lord. We are therefore of the opinion that in the facts that the present case, the decision of UPSC in forwarding 3 means against requisition of DOPT for 6 vacancies was inappropriate. We accordingly allow the present appeal, set aside the order of the High Court as well as the tribunal, and issue a mandamus to UPSC to forward the names of the next 3 candidates to DOPT for appointment to the post of section officers grade. They shall get seniority from the date of when Rajesh Kumar Yadav was appointed to the said post. Their pay shall notionally be fixed. and without any area to pay and other allowances, no cost. So my respectful submission, Lord, that the case of the petitioner, my lord, may kindly be considered, and my lord, he may be, the authorities may be directed to, my lord, consider the case of the respondent, my lord, respondent may be directed to provide absorption of the petitioner to the cadre post of LD assistant with effect from 8/8/1988. And my lord, when the petitioner was regularized from the service and consequential promotion of the petitioner to the post of UD assistant in the department with all consequential benefits to the petitioner in accordance with the law. That is my respectful submission.
That's all?
Yes, sir.
Sure.
Yes, sir.
Then you take your seat. Yes.
Lord, I'm the respondent of 5, my lord. My lord, my service has been regularized, my lord, as a LDA, my lord, not as a extra rider. By my lord, order dated, my lord, with effect from 1992, my lord. Order dated 24 to 1994, my lord. In my affidavit, I have annexed this order. Order at page, my lord, 7 of my affidavit, my lord. As a LDA, I have been regularized, my lord. His service was regularized as an extra item with effect from 1188, my lord. Thereafter, my lord, I have filed a petition, my lord,
You joined as what?
as an extra item.
When?
I joined, my lord, 26/6/1977.
And the petitioner joined in 1976.
Yes, my lord.
Then
Yes,
how
my lord.
you went above him?
My lord, as a LDA, my lord, my service was regularized on 94, my lord. And his service as a extra writer was regularized in the 1/8/1988, my lord. There is two different cadres, my lord, extra writer and LDA, my lord. I was directly regularized an extra writer, LDA, my lord, and he was regularized an extra writer. After my regularization as a LDA, my lord, I have approached this honorable court, my lord, for effecting the regulation with 1/8/1988, my lord. And that was, my lord, allowed, my lord. And later on, my lord, I was regularized with 1/1/1988, my lord, by creating a superannuation post, my lord. My lord, that order I have annexed, my lord.
Superannuation post.
Yes, my lord.
What is that superannuation post?
My lord, I have annexed, my lord,
Do you mean
supernumerary post, my lord.
Acha, you take your seat. Yes, Mr. Hendricks, please tell us what is the matter.
My lord, the initially my lord petitioner and the my lord that the respondent was appointed as a my lord that extra writer. After that, my lord, that those who are my lord completed the 7 years, their service has been regularized. And some of the my lord that petitioner my lord who was not completed the 7 years, then approached before this honorable court. And after my lord hearing this honorable court was said that those who are completed the 3 years continuous service, their service to be regularized. Accordingly, their service has been regularized. And my lord, that after that, my lord, individual and some my lord, the person they have been approached. I have told my lord that post my lord, to promote it to the post of LDA. The petitioner also approached before this honorable court. Lordship, my lord, can you see the page 21 of the affidavit filed by the respondent number 5?
Yes, page 21.
Page 21.
Yes.
Lordship. Relevant portion is my lord page 22.
So here regularization as extra writer was given from 1888.
Lordship,
That is the date on which the
Lordship.
petitioner also got it.
Lordship. My lord, that the petitioner was, earlier my petitioner was, my lord, the regularized since 1888.
Hmm.
My lord, the
So by virtue of this order of the court,
Lordship.
the respondent number 5 also got regularized.
regularized. And my lord, that he was.
Just a minute,
Lordship.
1888.
Lordship.
Now, how did the respondent number go and become LDA?
My lord,
before?
Lordship, my lord, that his UDA, LDA post has been, my lord, LDA has been, my lord, promoted in the year 1992.
Who?
My lord, that respondent number 5.
And respondent number petitioner?
Petitioner was not by my lord given the, my lord, that benefit.
Why?
My lord, that in person to this order, Lordship, my lord, he has been, my lord, that promoted.
But
My
this
lord,
order,
that there is,
this order is for regularization with effect from 1888.
but 1888, and ultimately, kindly say that the all Assam, extra writers, my lord, they have approached before this honorable court.
Where is it?
Eh? Come to the order to accelerate.
So he wants to be observed as LDA with effect from 1888,
Lordship,
not extra writer.
not extra.
But that case he has not argued. In fact,
Lordship.
nothing to say.
Like he was, my lord, challenged his, my lord, the promotion to the post of LDA before this honorable court. It was dismissed.
Where is that order?
Lordship, my lord, kindly see. Page 42
Page
of the
42.
writ petition, Annex 10. Relevant portion is 43, lords. I'll do.
So the same prayer was earlier dismissed.
Lordship. And
This-
my lord,
Thereafter,
he preferred and my lord, appeal was my lord.
Appeal was
Next.
deferred, my lord. Next page 47, my lord. Page 47 is the relevant portion, my lord.
He was withdraw this appeal, my lord, appeal lordship, and he was directed to my lord approach before this, my lord, authority,
Which
For-
authority?
my lord, that revenue department. And he preferred that, my lord, that representation before the authority. After that, he was promoted to the post of my lord, that LDA lords. 2011.
No, this order was passed on 2006, appellate order. And thereafter, in the year 2006, my lord, I filed representation. Annexure 12, my lord. Page 48. And this representation has not been considered, my lord. And thereafter, they, my lord, promoted the respondent number 5. Because appellate court direction was to file representation now before the authority.
Then what happened after the writ appeal order? What happened? He approached.
Approached.
And then it
After
was
that, he was
rejected.
sitting, my lord, he was. Whether he was arguing, my lord, they pursued the matter before the authority or my lord, we do not know. After the promotion of this, my lord, that respondent number 5, he again filed this petition.
All right. My lord, this writ petition is still pending, my lord. It is not disposed of. My lord, I was waiting for the outcome of this, my lord.
Which writ petition is still? pending?
Sorry, representation, my lord.
So
Annexure
you wait
12.
for some more time. You are already.
But tendency of this, my lord.
Your client has
this
retired
writ-
8 years back. You are still waiting.
My lord, the tendency
Right.
of this, my lord, this
I think.
representation, my lord, all
enough
this
time
has
has been given.
happened.
Yes. Good. Good. Take down. Heard Mr. B.K. Singh, Managed Counsel appearing for the writ petition. Also heard Mr. J. Hendrik, Learned Standing Counsel, Revenue Department, Assam.
1, 2, and 3, Lord.
Respond numbers 1, 2, and 3. Mr. D. Bora, Learned Government Advocate, Assam, appearing for the respondent number 4. And Mr. K. Uddin, Learned Counsel for the respond number 5. First up. The writ petitioner hearing had retired as an LD assistant, Law Divisional Assistant, bracket LDA, on attaining the age of superannuation with effect from 30/11/2015. The instant writ petition was filed in the year 2011 with the twin prayers of setting aside the order of promotion dated 29/1/2011, whereby the respondent number 5 was promoted to the post of UD assistant, and also to issue a writ of mandamus directing the respondents to absolve the petitioner in the cadre of LD assistant with effect from 1/8/1988 and thereafter. Give him the consequential promotion to the post of UD assistant with all consequential benefits. Full stop. The facts of the case, in a nutshell, is that the petitioner was originally engaged as an extra writer on daily wage basis with effect from 1/6/1976. Full stop. Thereafter, pursuant to a policy decision of the government dated 19/5/1989, the service of the writ petitioner, along with a number of extra writers who had served for a continuous period of 7 years was regularized with effect from 01/08/1988. Full stop. The respondent number 5 was also originally engaged as an extra writer, and therefore thereafter his service was regularized in the post of lower divisional assistant with effect from 01/09/1992. Full stop. While serving as an LDA by the notification dated 29/1/2011, the respondent number 1, along with 2 others, were promoted to the post of UD assistant. Full stop. On the same date, that is on 29/1/2011, the writ petitioner was promoted to the post of LD assistant, wherefrom he had retired on 30/11/2015. Full stop. Mr. Sen, learned counsel for the petitioner, has argued that his client ought to have been absorbed in the cadre of LD assistant with effect from 1/8/1988 and not in the cadre of, and not as an extra writer. Full stop. If the said recourse was taken by the authorities, then he would have ranked senior to the respondent number 5, in which event the petitioner would have a better right of being promoted to the post of UDA ahead of the respondent number 5. Full stop. In such an eventuality, submits Mr. Sen, the petitioner would be entitled to notional fixation of pay by treating him as an employee who had retired from the post of UDA. Full stop. On such count, the instant writ petition has been filed. Full stop. Contending that despite the retirement of the petitioner, the relief prayed for in the writ petition would be permissible in the eye of law. Full stop. In support of his above argument, Mr. Sen has relied upon the following decisions of the Supreme Court. Number 1 is Gurpal Singh. Number 2, Manoj Manu and another. You'll get all the citations. Then next is MP Singh Bargoti and A. Sagia Nathan and others. Citations were there. Mr. Handy, learned departmental counsel, on the other hand, has argued that the petitioner had earlier approached this court by filing writ petition numbers, by filing writ petition bearing civil rule number 6384/1996 with the same prayer, which was dismissed by the judgment dated 14/9/1999. Even the writ appeal preferred by the petitioner against the judgment dated 14/9/1999 was withdrawn with liberty to prefer a representation before the departmental authorities. However, there is nothing on record to indicate as to whether such a representation was ever filed by the petitioner, and if so, in what manner he had pursued the same. Mr. Hendick submits that due to failure on the part of the petitioner to pursue his relief, to pursue his remedy, and on account of long lapse of time, the relief prayed for by the petitioner cannot be granted in this case. Mr. K. Uddin, learned counsel for the respondent number 5, has argued that his client was regularized in the post of LDA with effect from 1/9/1992 However, the writ petitioner was promoted to the post of LDA only on 29/1/2011. Therefore, the petitioner cannot claim seniority over the respondent number 5 in the cadre of LDA. Consequently, the challenge made to the notification dated 29/1/2011 assailing the promotion given to the respondent number 5 to the post of EDA is not maintainable in the eye of law. I have considered the submissions advanced by learned counsel for both the sides and have also gone through the materials available on record. It is not in dispute that during the pendency of the writ petition, both the writ petitioner as well as the respondent number 5 have attained the age of superannuation and thereafter retired from service. Insofar as the claim of the petitioner of being absorbed in the post of LDA with effect from 1/8/1988, that is the date on which he was regularly absorbed as extra writer. The said prayer was made in WPC number prayer was made in civil rule number 6384/1996, instituted by the petitioner as the Assistant General Secretary of the All Assam Extra Writers Association. The prayer made by the petitioner was declined by the learned single judge by judgment dated 14/9/1999, holding that the writ petition was misconceived, was frivolous and misconceived. Even the writ appeal hearing number 385 of 1999, referred by the petitioner, was withdrawn by order dated 20/1/2006 with liberty to furnish particulars of the individuals seeking relief before the competent authorities. Mr. Sen has submitted that his client had submitted such representation and was awaiting the outcome of the process before the departmental authorities. Be that as it may, the fact remains that the petitioner had already agitated the same issue in the earlier round of writ petition. The petitioner had unsuccessfully agitated the same issue before this court in an earlier round of litigation. Therefore, the aforesaid aspect of the matter cannot be gone into in the present process. The aforesaid aspect of the matter, namely, whether the petitioner had a right to be absorbed in the cadre of LDA with effect from 01/08/1988 cannot be gone into in the present proceeding without any determination made by the departmental authorities on the representation to be filed by the aggrieved persons in terms of the order dated 20/01/2006 passed in writ appeal number 385 of 1999. Insofar as the case of the respondent number 5 is concerned, it appears that the respondent number 5 was regularly absorbed as an extra writer with effect from 1/8/88 due to the order dated on the strength of the order dated 18/11/2003 passed by the learned single judge in civil rule number 5402 of 1995. Is it civil rule 502 of 19? Civil number 5402 of 1995. First one. Thereafter, the respondent number 5 was promoted to the post of absorbed in the post of
540.
post of LDA. But such absorption of the respondent number 5 is not under challenge in the present proceeding. First of, if that be so, there can be no doubt about the fact that the respondent number 5 was born, born in the cadre of LDA on a date prior to the date of regularization of the petitioner's service in the cadre of LDA. If that be so, I do not find any justifiable ground to hold that the promotion of the petitioner, promotion of the respondent number 5 to the post of UDA ahead of the lead petitioner was illegal, and therefore is liable to be interfered by this court. Full stop. What is also significant to note here is that the lead petitioner did not take sufficient steps to pursue the remedy before this court while he was in service. Full stop. This fact, when viewed in the light of the fact that the petitioner had never challenged the regularization of service of respondent number 5 in the cadre of LDA ahead of him, is sufficient for this court to hold that the writ petition is not maintainable in the facts and circumstances of the case. Moreover, the relief as prayed for by the petitioner also cannot be granted to him in the facts of the case, as the delay in pursuing the remedy by the petitioner, in the opinion of this court, cannot be treated as inocuous delay. Full stop. It is no doubt correct, Mr. Sen has relied upon the decisions of the Supreme Court to convince this court that even at this stage, this court will issue a direction to the authorities to promote the petitioner to the post of UDA and thereafter direct notional benefits to be extended to him in terms of his pay oblique pension. This, I'm afraid, such submission of Mr. Sen cannot be accepted for the reasons stated herein above. Moreover, the decisions relied upon by Mr. Sen appears to have been rendered in the facts of those cases. Full stop. After a careful reading of all the decisions relied upon by Mr. Sen, I am of the view that those citations do not have any relevant bearing in the facts of the present case. For the reasons stated here and above, this court is of the opinion that his writ petition is devoid of any merit. The same is accordingly dismissed.
All right.
All right. You have tried, Mr. Sen. You have tried. We do our job. Yes.
All right.
Maybe you. Yes, what is this matter?
My lord, the selection process to the post of an Anganwadi helper, that is under challenge, my lord. Now, my lord will see the earlier two orders where your lordship had directed the respondent authorities to produce a copy of the select list that was never published after the interview was held. And finally, my lord, on the last occasion, a purported select list was filed, not by way of any affidavit, but just produced in the court and given. My lord, just a list of candidates who have been declared selected. My lord will turn to the affidavit, the select list, purported select list, my lord will find that there's nothing there to indicate that any comparative assessment was made of the.
Let us understand what is this case. Affidavits have been exchanged.
Affidavit
Pleadings
filed,
are
as per the
complete. my lord.
Respondent number 3 filed the affidavit, lordship. In the affidavit said affidavit, this clearly stated that the select list was published, lordship, and on earlier occasion 3/5/23, lordship, the select list was submitted before the court, lordship. And also served to the petitioner council also.
Who is appearing for respondent number 5?
Lordship, I am preparing for the respondent of second. Here is the case where the mother of the petitioner is the Anganwadi worker. We have filed our affidavit.
Moreover, lordship, kindly see the prayer portion, he has set aside the appointment letter, lordship, that he was not challenged the selection list, lordship. Select list was published, lordship. On that basis, appointment was made, lordship.
My lord, I'll come to the select list, my lord. Well, since a lot of thing has been made on the select list, my lord will just turn to their affidavit in opposition, my lord. On the basis of their affidavit, I can prove my case, my lord. How contradictory.
What is your, first, please open up your case. What is?
My lord, pursuant to an advertisement, which my lord will find at page 21.
Page 31,
Page 21, my lord.
page 21.
My lord, an advertisement was issued to fill up various posts of Anganwadi helper. My lord, the advertisement is at page 21, section D. And I applied in respect of serial number 5, man.
These are all Anganwadi helpers.
Helpers, my lord, not workers, helpers. And my lord, and after which, my lord, there was an interview.
Your client applied for Bingorati 1.
Yes, my lord, that's serial number 5.
All right, then
Then, my lord, there was a lot of dilly-dallying on the part of the authorities to publish the select list. So I filed an RTI application, which my lord will find at page 25, asking details of the appointment. My lord, that was not responded to. And I had to come to this court seeking a direction to call for the records and force the appointment of the private respondent. Now, my lord, they have filed an affidavit in opposition. My lord, this was filed on the 21st of August, on the 19th
no,
of.
we are not finished in the writ petition yet.
My
So
lord,
that's all. You filed the RTA, that's all.
After which I had to approach this court, my lord, when there was no response forthcoming.
So you applied and you participated in the selection
Selection
process,
process.
then you filed RTA.
My
application.
lord.
That's all. So what is the prayer here?
Raised,
Watching the
my lord,
appointment.
watching the selection proceedings of pertaining to the private respondent number 5.
Mr.
I have been-
Mohanto, you're waiting for which case? Supplementary admission. Let us see what happens.
My lord, since 2019, I've been working as a helper in the same center till the time the advertisement was released. And my lord will find the discrepancies insofar as the select list are concerned, my lord. It is their case that I was a regular student. I was a student because of which I was not entitled to be eligible to participate in the selection process. My lord, whereas the facts indicate otherwise, my lord. I have completed my HSLC, my lord, and that is the minimum qualification that is required. And I was never studying at that time. And that is, that pertains to 2016. When I was appointed, and the advertisement was released in 11/11/2019. That is one, my lord, discrepancy. The other most significant, my lord, when the affidavit in opposition was filed by the respondent number 3, my lord, the select list was already there with them, but it was not annexed with the affidavit in opposition. And the select list was published, brought to the records after repeated orders by this court, my lord. There are 2 orders, my lord, which my lord will say on 14/12/22, 12/12/22, and 14/3/2023. 2 orders of this court, after which the purported select list was produced in court and just handed over. Not filed by way of an affidavit. The records were not produced.
Record was never
And-
called for, Lordship.
And my lord, the fact remains that, my lord, on the day the affidavit in opposition was filed by the respondent number 3, my lord, there was already a select list available, which was for reasons known to them. They were not
What is the
respected.
relief you want here?
I want that the selection process should be quashed, my lord, and
How
and
can it be done? On what basis?
on the basis that the selection is vitiated.
On what ground?
On the ground that the affidavit in opposition that has been filed, that is based on a fundamental flawed premise. That I was,
Oh, select list cannot be quashed on the basis of affidavit. You have to make out a case.
when
for the
it is,
select list.
when it is based on a factually incorrect basis, then, my lord, the court of equity has ample
Oh,
powers
no,
to.
no, Mr. Srinivasan, there is some problem here. Whether affidavit is filed, not filed, whether it is defective, whether it is correct, that is a different matter. That may be relevant. But to set aside a selection, you have to make out a case on merit, not because the affidavit is wrong. What is your case on merit?
It is not wrong, my lord. It is very wrong, my lord, for the reason that, my lord,
Oh, then we'll
They-
not be able to pass this order.
my lord,
Will not be able to set aside selection because the affidavit is wrong. That order cannot be passed.
if it is based on a flawed
No,
premise,
nothing.
my lord, will just
Affidavit
bear
in-
with, my
In
lord,
cases, there may not be any affidavit.
2
also.
minutes, my lord, 2
Yes.
minutes. My lord will turn to their affidavit in opposition at page 6. I'll draw your lordship's attention to just one paragraph.
Yeah, affidavit in opposition filed by respondent by.
3, respondent number 3, the
Alright.
CDPO. Page, the relevant paragraph is at 16, paragraph 16, my lord,
Yes, paragraph 16.
16.
Yes,
That
please.
may I read, my lord?
Yes, please.
That with regard to the statements made in paragraph 14 of the writ petition, it is stated that an advertisement dated 11/1/2019 was published for selection and engagement of Anganwadi helpers in 6 numbers of AWC under Lahorigarh ICDS project, including Dingorati 1 AWC. On completion of the selection process, this is relevant, my lord. On completion of the selection process, the selected candidates have been engaged as AWH in the above AWC. The writ petitioner, though participated in the selection process, failed to get election. The writ petitioner was a regular student and thus not eligible to participate in the selection process in terms of the advertisement. So this is the only ground on which my candidature has been rejected or not considered.
No, followed. So your candidate,
I am not a regular, I was never a regular student. I have finished my education, I mean, HSLC, and I have been working here and there. My lord, I was never and that has not been substantiated. Not been substantiated. It was required that when my candidature has been cancelled, it should be on the basis of facts. And this here, my lord, there is the fact that I was a regular student is not a fact, because, my lord, I have annexed at annexure A of my writ petition that I am an HSLC pass candidate. That is all. I was not pursuing studies.
what is the rejoinder to this?
Rejoinder is only on the point of the selection process, my lord.
Not on the
Denial of facts, my lord. Because I was working from 2016 to 2019.
No, I'm asking, there is no rejoinder to para 16.
No, my lord, no, that is their affidavit, my lord.
You have not.
I have denied it, I have just reiterated what I.
Where is that part?
Where is my, the same affidavit? Reply to this.
What is the response to para 16?
My reply at 16, my lord, paragraph 6. That was with regards to the statements made in paragraph 14 to 21, the writ petitioner, while reiterating the statements made in the corresponding paragraphs of the writ petition, states in reply that the writ petitioner is fully eligible to participate in the selection process and fully competent to challenge the selection process in view of what has been stated above, reflecting the arbitrariness in the partisan manner through which the private respondent has been selected. The selection
So
process.
you say that your client was, the statement made that the writ petitioner was a regular student
Yes,
and therefore not eligible to participate in the selection process is not a correct statement.
it is not a correct statement.
Where is your denial of that? Show me that. If you have denied it, we'll ask them to substantiate. Otherwise not.
Lordship, in the advertisement, Lordship.
Please take your seat.
Except for a general denial, my lord, there is nothing specific to that point.
Seniority.
I will not
You
waste.
know what is what. General
But-
denial
but-
now.
But my lord, can that be a ground, my lord? When I have denied it and on the face of the record, my lord, it is shown that the statement is unsubstantiated.
No, they say that you are not eligible to take part in the selection process.
Which
Please,
I'm
please
disputing,
listen,
my lord.
listen. We are communicating because we want the best to come out. Otherwise, you can make your submission, I can dictate my order. But the reason for communication is that so that we know with clarity what is the issue that is being projected. Their stand in the affidavit, which is pleaded stand, is that your client was not eligible to take part in the selection process because she was a regular student. That is their averment. Now, if that is not correct, you have filed your rejoinder. The petitioner could have easily said that, no, it is not correct. I was not a regular student on that at that point of time, and therefore I was eligible under the advertisement to participate. Once that statement is made, the court would naturally ask them on what basis they made this. But that statement is not there, although the rejoinder has come. So how the court will go into other aspects? If she is not eligible, that's the end of the matter. Is it not correct? She has not denied it. It is not an accidental issue. It
Oh,
is a
my-
pleaded contested issue.
My lord, we will turn to paragraph 2.
Paragraph?
Paragraph 2 of my writ petition.
All right.
The adverting to the facts of the case, the petitioner has passed her HSLC examination under the Board of Secondary Education Assam in 2016, and due to adverse circumstances could not pursue further studies. He was compelled to look for gainful appointment to help find a family, eke out a living. So that is one aspect of the matter, and where I'm not pursuing any studies.
So where is
Beyond
it
that.
stated that?
But my lord, that is indicative of the fact that has not been controverted, my lord, by the respondents.
All right, you complete your arguments. Can the court record specific findings on the basis of these? That their stand that she was not eligible is wrong. How can this finding be
But
recorded?
there is a denial, my lord, there is a denial, and it is bolstered by the fact that that paragraph 2 of my writ petition says that I have, because of my adverse circumstances, I could not pursue studies beyond HSLC. And therefore, and the advertisement, the criteria, the parameters laid down, I fulfill all those parameters, my lord, and HSLC is the minimum required, and I have that. So where did this thing spring from? You just can't make a bold statement saying that she's a regular student without substantiation.
Where is the clause in the advertisement that persons who are pursuing study will not be eligible?
Lordship, in the said advertisement, he has also annexed only one person, Lordship. In eligibility criteria, he was not the annexed, Lordship. That's why my submission is he is a regular student, Lordship. In the eligibility criteria portion, Lordship, he has not annexed, he has not annexed.
Which is the clause?
Lordship, kindly page 23 of the read petition, Lordship. Advertise in the said advertisement.
My lord will take into consideration the fact that the so-called advertisement was hung up in the notice board. It was hung up in the notice board. My lord, there are so many people, eyeing the notice boards for advertisements or tender notice or whatever. There is a likelihood of the notice being torn away or taken away. But my lord, what is more important is the advertisement which I have annexed, Annexure D. That is what was available in the notice board, and that is complete by itself. That is complete by itself. And my lord, the fact is that the selection committee conducting the selection process, my lord will just tell to their select list, my lord. It has not been signed by any of the members of the selection committee, nor do we know, except for the statement made there, it has not been substantial, no annexures.
But have you challenged the select list? Its copy was given to you.
It was given to me last week, my lord, on the last occasion. It was given on the last occasion. The selection committee, none of them have been named, and the copy that was given to me did not contain any signatures of the selection committee. By their own admission, my lord, there was a duly constituted selection committee. Whether it was duly constituted or not, I don't know, my lord. There was a selection committee. And none of the members of the selection committee signed the select list. So my lord, the cloud hangs over the selection process, my lord.
We'll admit it and put it to regular hearing.
Okay. Hello.
All right?
Hello.
In usual course.
All right.
There is no interim order.
No.
Heard Mr. T.N. Seniority, learned counsel appearing for the petition.
There is an order of status quo, my lord.
No, Lordship.
The first order.
No, she is, respondent number 5 is working.
We are working, my lord, as per the instructions I have, and they say that we are working. Well, I will know that. But the fact remains that there is an order of the status quo, my lord.
Then we'll dispose it of today itself. You complete your argument.
Well, that is it, my lord. My case rests hinges on the select list, my lord. Whether it can be acted upon, whether the selection process is vitiated based on the submissions, my lord, that is it, my lord.
All right, then we'll pass an order today itself. Yes.
Obliged, my lord.
Yes, Mr. Chakraborty. Yes, what is the submission?
No, so my submission is not.
Where is the clause in the advertisement about regular student not being eligible?
Lordship, in the said advertisement clause 2, Lordship. Clause 2, yes, not annexed, Lordship.
But what prevented you from annexing?
Lordship,
You could have done it.
Lordship, I have, it is a vernacular, Lordship. In vernacular language, I have received, Lordship. That it's stated that in the vernacular, Lordship, প্ৰাৰ্থীগৰাকী বয়স চলিত বছৰ 1 জানুৱাৰী 2019 পৰা 18 বছৰ 44 বছৰৰ ভিতৰত হ'ব লাগিব পঢ়ি থকা ছাত্ৰী সংক্ৰামক ৰোগী মানসিকভাৱে অসুস্থ গৰ্ভৱতী আৰু প্ৰসূতি মাতৃক নিৰ্বাচন কৰা নহয়
But what is there to substantiate that I fall in that category, any one of those categories? To debar me.
And you have not denied that.
My lord?
You have not denied that.
My lord, I have already established, my lord, that I was not a student. I had stopped studying in 2016, my lord, and the selection process started in 2019.
Yes, what else?
My submission is, Lordship, she is a regular student, Lordship. That's why the advertisement was not annexed, whole advertisement not annexed, Lordship. Only one person he has annexed, Lordship.
How am I going to
The eligibility criteria he has not annexed. Yes, we know that she was a regular student.
My lord, I've just been informed that my client is working, my lord.
Matter today, sir.
His lordship, what happened, lordship? The earlier Anganwadi worker expired, and the mother of the petitioner, who was earlier work as Anganwadi helper, now she was promoted to Anganwadi worker, lordship. Then in the post, the mother of the petitioner desperately wanted to accommodate the petitioner, lordship. Page 16 annexure B may kindly be seen of the writ petition for a moment, lordship. Annexure B, page 16. Lordship, kindly note the date 2/5/2016. And I have seen the affidavit sworn in by the petitioner, where the petitioner has mentioned her age as 21 years in the year 2021. If we count, lordship, then the age of the petitioner comes 16 years during 2016, lordship. And the mother of the petitioner, serial number 8, lordship. Serial number 8 of page 16 is the mother of the petitioner, lordship. They supposedly adopted a managing committee adopted a resolution to appoint the petitioner as Anganwadi helper, lordship, at the age of 16, lordship. And the Anganwadi managing committee is not the authority to select or engage any candidate, lordship. How the petitioner, all the basis of.
So petitioner's name is not there in the select list.
No, she was not considered. For the reason which probably
Lordship,
come to this court.
in my affidavit of opposition,
Controverted that, then we could have done it. No, that will not accept, Mr. Singh. Don't repeat it. When in the counter affidavit, they've taken a categorical plea, you are silent on the rejoinder, that will be treated as accepted. Can't help it.
In spite of my general.
No, in spite of, we'll clarify it. You test it. That is not a categorical environment. All right, that's it. We are not going here and there. Heard Mr. T. N. Srinivasan, learned counsel appearing for the writ petition. I also heard Mr. H. Chakravarti, learned government advocate Assam appearing for the respondent numbers 1 to 4. 1 to 4. Mr. Your name, please?
I am R. Islam.
Huh?
R. Islam.
Mr. R. Islam, learned counsel is appeared for respondent number 5. 1 to 4 and 6. is it?
6, lordship, 1 to 4 and 6, lordship.
Respondent number 5. Full stop. The facts of the case, comma, in a nutshell, comma, is that on on 11 June 2019, the Child Development Project Officer of Lahori Ghat had issued an advertisement notice inviting applications for appointment of Anganwadi helpers in as many as 6 Anganwadi centers coming under his jurisdiction. Full stop. In response to the said advertisement notice, the petitioner had submitted her application in for the post for appointment as Anganwadi helper in respect of Bingorati, BINGORATI dash numerical 1 Anganwadi Center. Full stop. According to the petitioner, a selection process was held, but thereafter the respondents did not publish any select list. Notwithstanding the same, the respondent number 5 had been appointed to the post of Anganwadi helper in respect of, is it Dhingorati or Bingorati?
Dingorati.
DHI, Dingo, not Bingo, Dingorati. Number 1, AWC, full stop. Taking note of the, no, On receipt of notice. You write, where is the order of status quo dated?
Well, that is so. 1/12.
Taking note of the
One,
case of the
two,
petitioner,
2021.
this court had passed order dated 01/02/2021, issuing notice upon the respondents, and in the meantime, status quo as regards the post of Anganwadi helper in the number 125, Dhingorati -1 Anganwadi Center was directed to be maintained. Full stop. The respondent number 3 has filed counter affidavit contesting the case of the petitioner, inter alia contending that as she was a regular student, hence the petitioner was not eligible to participate in the selection process as per the terms and conditions of the advertisement notice dated 11/1/2019. Full stop. The respondent number 5 has also contested the case by filing a separate counter affidavit. Full stop. Apart from that, since an allegation was made by the petitioner's counsel that the respondents had not prepared any published any select list, this court had directed the respondents to produce select list. Full stop. Produce the select list. Accordingly, the select list dated 11/11/2020 was produced before this court with a copy having been furnished to the petitioner's counsel. Full stop. The aforesaid select list does not contain the name of the petitioner. Full stop. From the above, it is apparent that the respondents had published a select list of the successful candidates, but the petitioner's name did not feature therein. Full stop. Moreover, it is the pleaded stand of the departmental authorities that in view of clause, what is it, clause?
Clause 2, Lordship.
Clause 2 of the advertisement notice dated so and so, which does not permit a regular student to take part in the selection process. The petitioner was not allowed to participate in the said process. Full stop. In the rejoinder affidavit filed by the petitioner, the said averment has not been traversed, nor has it been denied by the petitioner. However, Mr. Seniority has made an attempt to overcome the said deficiency in the rejoinder affidavit filed by the petitioner by relying on the statements made in para 2 of the writ petition, wherein the petitioner has simply stated that she had passed her HSLC examination in the year 2016 and due to adverse circumstances would not pursue her studies any further. Full stop. Be that as it may, the fact of the matter is that there was a selection process conducted by the respondents in terms of the advertisement notice dated 11/2/2019, whereafter a select list was published. Full stop. The petitioner, despite being aware of the select list, did not take steps to challenge the same. Full stop. In view of the above, this court cannot now go into the validity of the select list. Full stop. The aforesaid aspect of the matter, when viewed in the light of the stand taken by the department that the petitioner was not eligible to take part in the selection process due to clause 2 of the advertisement notice not having been controverted by the writ petitioner in the rejoinder affidavit, this court is of the opinion that there is no scope for making any further inquiry into the matter. Full stop. Apart from that, it appears that the authorities have already issued the appointment order in favor of the successful candidate. Therefore, at this stage, therefore, there is no scope for this court to interfere with the aforesaid appointment order in the facts and circumstances of the case.
For the reasons stated here and above, this writ petition is found to be devoid of any merit. This will be according to question.
Right, on that.
May it please your worship.
Yes.
My lord, in this particular case, I have challenged the validity of two orders, my lord. The first order whereby I have been dismissed, my lord. And second order regarding the appeal, I filed the appeal and the appeal was also rejected, my lord. My lord, in this particular case, the petitioner was appointed to the post of the constable, general duty on 22/7/2006. 2006, my lord. And during my service, my lord, I obtained the leave for 1 month, my lord. From 10/1/2019 to 9/2/2019. For 1 month, my lord. 10/1/2019. For the purpose of treatment of my mother, my lord, who was suffering at the relevant time by liver cancer. my lord. What has happened in this particular case, my lord, subsequently I did not join the duty and several notices had been issued to me. And after that, the termination order was passed. That you will also find at page 26. And it's an email. That was 17/6/19, man. May I read it, my lord?
Yes.
Whereas such and such, but Brother Raj Singh, son of such and such, state of Assam, is overstaying after expiry of sanctioned leave with effect from 10 to 19 afternoon without prior permission of competent authority. And whereas communications directing you to assume your duties were issued at your home address by memo number such and subsequent reminder letter such, but you failed to assume your duty. And whereas a court of inquiry was ordered by order number such, there is 30 days of after expiry of 30 days of the absence without leave as per provisions contained in section such. And whereas on receipt of CIO report, I, the undersigned, after having satisfied with the opinion that the COI made a record there under justifying your absence without leave, an inventory of government property in your possession, copy of the inquiry is included, and whereas apprehension roll was issued to the concerned police authority to apprehend you by letter number such, and is demanded by letter number such. And whereas when neither you have surrendered yourself either before the police authority or the union, nor you were apprehended by the concerned police, you were declared as deserter, wide order number such, as per provisions contained in section 74(2) of SSB Act 2007.
Who is appearing for the respondent? You got the records?
Records, I don't.
Records will not be necessary.
May be necessary.
Then we fix it after vacation. Let her produce the records. Huh? All right. Heard Mr. O.P. Bhatti, Learned Counsel appearing for the petitioner. Also heard Ms. B. Sharma, Learned CGC appearing for the respondents. Since the writ petition has been preferred against an order of dismissal from service passed against the petitioner, it would be necessary for this court to peruse the records.
Ms. Sharma submits that the records are not available today. In view of the above and on the request of learned counsel for both the sides, this matter is directed to be posted again on 8th of August 2023 as a fixed item in the column of disposal at the stage of admission hearing within court. On the next date fixed, the departmental records shall be made available. 8th of August.
Minutes, please, Lordship. All of these petitioners were originally Khalasi and PSC, but they are appointed is prior 1/4/1993. So general notification, my lord, they are entitled for regularization, but in the meantime, in 90, they are transferred to Jal Board, my lord, Assam Water and Water Supply and Suez Board. So when they are in deputation, their service was regularized. But 2011, they are reverted back to parent department, and parent department says that they should be posted at the original Khalasi post, and that is master status minus. Now, that is why this executive engineer page 40 has written a letter that they should be regularized because there are others incumbents who are parent departments, they are regularized, and they just left out. Now, in the regulation letter, they said that their stand is that the government approval is not taken. But in the letter, my lord, regulation letter, there is a mention of letter, government letter, pursuant to that their regulation is done. Now, that is the issue whether.
Yeah, you have instructions, Mr.
Lordship, we have instruction, but the instruction doesn't clearly says anything, your lordship. There's nothing to counter with the stand, your lordship. At
But
best,
have you filed affidavit?
lordship, at this stage, I wouldn't say I would file affidavit, but at the best we can consider his representation which he has filed, your lordship. Regularization.
What is this? Let us see.
Representation.
Where is the representation?
Representation, my lord.
Have you submitted?
This-
it?
No.
Page 40, my lord, this is the communication where
The executive engineer has, say, a written letter chief engineer asking for regulation, lordship. In fact, a similar set of representation were filed where that page number, your lordship, 41, your lordship.
a relief is given by this honorable government.
That's the same.
Some similarly situated has get relief, my lord, already in different way, my lord, 28 years is service, and that is page 40, my lord, that is the communication, my lord, from executive.
Just a minute, just a minute. So they were earlier regularized.
Yes, my lord, page 33.
After regularization, how can the?
Yes, lordship. They were regularized in the sewage board, and
Hmm.
according to my understanding, once a regulation is given, it can be taken back, your lordship.
It cannot be taken back.
Yes, lordship. According to my understanding, your lordship.
Page 33, my lord, kindly see this regulation order, my lord. 10/2/2006, and there is a mention of government approval. Second column.
Actually, you have not implemented finance,
My lord.
cannot be disposed of.
So if lordship
Hmm.
permit me, I can manage.
Yes, heard Mr. M. J. Borwal, head counsel for the petitioner, also heard Mr. R. Gogoi, Learned Standing Council,
PhD
PhD Department, Assam, appearing for respond number
Correspondent number, your lordship. 1, 2,
1, 2,
1, 2, and 3.
1, 2, and 3. After hearing the submissions of learned counsel for the parties, This court is of the opinion that the writ petition can be disposed of at the stage of admission hearing. However, no such order can be passed without hearing the Finance Department, Assam, which is not a party to this writ petition. In view of the above, and for ends of justice, the Secretary, Commissioner Secretary to the Government of Assam, Finance, which is this Finance B?
Finance B, your lordship. Most probably
Finance
B.
bracket B, bracket plus Assam, is hereby implemented as a respond number
Respond number 5.
5. Registry to make the necessary endorsement in the cause title of the writ petition and list the matter thereafter by reflecting the name of learned standing council finance, Assam in the cause list. Petitioners counsel to furnish a copy of the writ petition to the standing council finance.
Obliged. Petitioner. Petitioner. My respondent.
Another case, my lord, there are two cases have come. Another case, my lord, that is
That's
2160
correct,
of
which they filed. Actually, the first one, they have challenged the fact that we do not have an appellate authority. I mean, for appealing against the internal committee report under the POSH Act. And the last case they filed is about for hearing the challenge the report. So if one case matter says the other has to go, if I appoint the appellate authority, then the last case becomes infructuous here. He has to go avail the appellate.
the WPC number 2160 of 2000.
So it's best if the lordship disposes of the first case first.
That has not come.
Number 2961 of 2022. What is the relief there?
2961, exactly. They want us to appoint an appellate authority
There was a party appellate authority for disposal of the appeal.
for disposal of appeal
appeal.
under the POSH
So
Act.
you are willing to do that?
If lordship gives me a direction, because my service laws really do not have an appellate. Oh, sorry. My service laws do not have.
Because they have adopted the POS Act by law.
No, POSH Act is, I don't have to adopt, it's there.
Is there, but so far as the appointment of appellate.
POSH Act has provisions for an appellate authority.
Yeah.
Yes, lordship, but
So
we
you
have
have to set it up, that's all.
we have to set it up. that's all.
Notify.
Yes,
That has not been done.
that I will do. Lordship may give us reasonable time and then he can appeal there.
So if with that direction, if this is disposed of,
Yes.
then the other will be closed.
No, the other is regarding.
No, the other one is also, the
Regarding
next one is
suspension.
suspension, but suspension appeal lies against the suspension order. There's a provision in the service laws.
Appeal, my lord, we have filed before the after for review. my
No,
lord.
that-
They have not reviewed it, my lord.
No, you have filed for the IC committee report, against the IC committee report, not against the suspension. A
Anyway, my
suspension-
lord, actually, my lord, all the matters come, my lord, because this by client has also engaged, my lord, K. Chaudhary in this case, my lord, recently, my lord.
Sorry, client is?
Engaged K. Chaudhary, my lord. So his presence also, let him come next week, my lord, along with this other.
No, next week, no, if it is not held today after vacation.
then
After vacation.
Mr. P. Kotakil, a counsel appearing for the petitioner in both these petitions are paid for posting these matters for admission hearing. Again, after the ensuing summer vacation, on the ground that a senior counsel has been engaged in this case by the petitioner to argue the matter. Ms. M. Hazarika, and senior counsel is paid by Mr. D. Khan, a counsel appearing for the respondents. Numaligor Refinery Limited, they will put it. Numaligor, what is it? Numaligor, is it?
Yes.
What is Numaligor Prasad Sharma?
Nihar Prasad Sharma is the
Petitioner.
petitioner.
Acha, now in the file, somebody has written Nihar Prasad Sharma versus Numaligor Prasad Sharma. So I am a little
Lordship,
Numaligor Refinery Limited submits that some time be given for her to obtain instruction as to whether the refinery authorities would be willing to notify an appellate authority under the provisions of the POSH,
yes.
which is called POSH, which act has already been adopted by the refinery.
Yes.
Acceding to the prayer made by the counsel for both the sides, let these matters be listed again on the 4th week of July 2020.
Along with WPC 2160,
Along with WPC number
2160 of 2020,
2163 of 2020.
23.
And lordship, pendency won't be a bar to appoint an appellate authority. as per
It is
the act.
further made clear that a pendency of these writ petitions shall not be a bar for the refinery authorities to notify the appointment of appellate authority
Under the POSH
under
Act.
the POSH Act.
Obliged.
Mr. Mahanta, Thursday will be a better idea. Because if we start now, I would like to dictate the judgment in the court. There's no point taking these matters. Already things are there inside. So,
Lord, one aspect just I like to draw your lordship's attention. Lord,
but what is there in these cases now?
Lord, on last 3-4 occasions, my lord, the issues were like non-furnishing of the OMR sheet, non-disclosure of the answer key and all those things, my lord. Answer key has already been, final answer key has already been declared, published, pursuant to your lordship's order, my lord. Now, the moot question that we raised in the writ petition is like, there were 3 questions in GS2 paper and 1 question in GS1 paper. Apparently, those 3 questions, out of those 3 questions, the answer keys are apparently wrong. We have given the textbook and the relevant material, and 1 question in the GS1 paper, my lord, in that question, answer key as well as question, both are wrong, my lord. So,
but are those pleadings there in the?
Yes, yes,
my lord.
there is no-
that is the question, my lord.
I'll show, my lord. Pleadings are there. My writ petition, my lord.
Original writ petition. the pleading-
Original.
That is the question, my lord.
If
Mr.
it-
Das, you see,
Lord,
listen.
Yes.
You can do whatever you feel like,
No.
but we will go into these issues and on technical grounds we'll dismiss the report.
Lord, you will kindly appreciate in, so far as, my lord, 3 questions are concerned, my lord, 2 questions we raised in the writ petition, 1 question with regard to GS1 paper, that question we came to know about the correctness or, my lord, of the answer key as well as question. We came to know when they did not corrected the answer in the final answer key.
Correct. So now,
So that-
if you are given marks for these questions,
Yes,
then
No.
what happens?
no marks given.
If
Because
you are
they-
given today, what will happen?
We'll clear, my lord.
There is not the pleading, my lord.
No pleading is
All right.
required, my lord. I
Then I'll
get
hear
2
it
marks.
today.
My lord, I get 2 marks. If that mark is given to me, I get 2 marks. So if I am one of the petitioner, he short of 1 mark, my lord. He get 2 marks and he is eligible for appearing in the mains examination. As simple as that. So what I'm trying to submit to, although the reason for making this submission is that, my lord, I'm also aware of the position of law that even if I raise the question that the answer key of these 2 questions or 3 questions are wrong, or the answer key as well as the questions are wrong, my lord, this honorable court may not be inclined to go into the correctness of the questions because the power of judicial review is extremely limited. So my prayer at this stage would be that this question your lordship would like to send to the expert and get a, my lord, result, because all the, my lord, Supreme Court judgments I have seen, my lord, 4, 5 I have brought, wherein, my lord, wherein this question was raised, or any question which were questioned by the candidates, my lord, the high courts at the very first instance send the matter to the expert, get a result, then thereafter, my lord, deliberate it. So at this stage, my humble prayer before your lordship should be, lordship will kindly send these 3 questions to the experts, get a feedback from the experts, and thereafter lordship will decide about the outcome of the writ petition. And in the meantime, lordship will kindly permit us to appear in the main examination, since although there is some time for the main examination, 8, 9, 10 July is the date. If in the interregnum period the my lord, experts' decision comes, then also lordships can finally decide the matter. Well, that is my entry. And 1 question, that is the GS1 paper, answer, of which I am saying that answer key as well as the question is wrong. My lord, in fact, there is no requirements of any inferential reasoning also. On the face of it, Milord, that answer key as well as question is wrong. And if your
No,
lordship,
no, 1 minute. You are appearing in which case?
no, my lord, I am appearing in WPC number, my lord, 2384, that is item number 23, my lord.
2384.
84, 2023.
Give me the file.
Lord,
Hmm?
my lord. Your lordship, kindly, my lord, one thing, my lord, there is a, my lord, circular issued to all the candidate after publishing the, my lord, provisional answer key, my lord. They were asked to raise any objection. If you have, you can, there's a format, you can lodge the complaint and we'll send it to the F. But he has not done it, my lord.
Let me understand what is this case, then I'll.
No, my lord, these are, my lord, not done with pleading, my lord. They are come, my lord, with him, because that's why your lordship asked me to file the affidavit.
You want the court not to hear it?
My lord, sorry, my lord.
No,
my
if
lord,
that is your submission, then you argue.
No,
I am only saying, let me hear what
My
is
lord.
this case.
No, my
Yes. 2384, you are appearing only in this
Yes.
case?
Yes, my lord, only in
All
this
right.
case.
How many petitioners are there
My
here?
lord, there are 9 petition, 10 petition. 1 second. 10 petitioners, my lord.
10 petitioners.
Yes, ma'am.
Okay, now. All these 10 petitioners, they have not got the cutoff mark according to the APSC. To
Yes.
write the mains examination, is that correct?
Yes, my lord.
Right.
Some of the petitioners, my lord, they failed to get the qualifying marks in GS2 paper, that was 66. And some of the petitioners, they failed to get the cutoff mark in GS1 paper.
But these are all now jumbled up because when you came to the court initially,
Yes.
your grievance was that there is no transparency, correct?
My lord, actually,
Listen,
yes,
listen.
I understand. Yes, yes.
Once the court passed some order, some numbers were
Yes,
given,
yes.
some OMR answer key was
Yes.
given. Then it transpired that some people have got some advantage, something to argue. Some people don't have something to argue.
Yes.
Now, the court had asked you, would you like to withdraw and come back with specific pleadings for the specific petitioners so that we can pass specific orders? You are not willing to do that. Therefore, on that ground, I'll have to dismiss all these cases today. You are. These are technical things, but we have to go by it. We can't go into a jumbled up writ petition like this.
Lord,
Some people have got some cutoff mark in.
I understand, my lord, the
stages.
query of your lordship, my lord.
The time
But
is.
this jumble was not created by the petitioners, my lord. I'm just trying to explain one thing, my lord. Lordship will kindly appreciate, my lord. We participated in the prelim examination. We participated. My lord, they declared the result. On the same day, they declared the provisional answer key. Had they would have released the final answer key on that day
That's
itself.
a very valid point that we'll hear in due course of time.
That
We'll
is-
admit
I'm
it
trying-
here. If you want immediate relief, those arguments are not going to work.
No, that is
Sorry.
not my argument, my lord. That is what I'm trying to satisfy your lordships about the sequence of events. So on the day when we approached this honorable court, my lord, we were absolutely clueless that what were the reasons. Because when we went to the office of the APSC, they say, my lord, for 10 petitioners, they say for this reason, a clerk or someone was
All right,
there.
that is your argument. Anybody else is willing to take this liberty, that specific case on the basis of specific pleading?
My lord, may I also say one thing? my lord?
Yes, yes.
With the apprehension that this may be because we were told that for this reason you didn't bubble the darken the bubble, so for this reason your case was rejected. On that context, my lord, I have incorporated pleadings. It is not that pleadings are not there. Lordship will get all the pleadings in the writ petition
All right,
for
we'll
all
hear
3
it.
category of persons. my
We'll
lord.
hear it. And we'll hear it on Thursday. But I have given enough warnings to you that
I'll
this
try
could
to-
be the ground
These are all
on which-
students of 25, 26 years old. And if there is shortage of pleadings, I'll assure lordship will not get any shortage of pleadings on these 3 regions. my lord.
we will pass one order. If one order
Lordship,
covers them.
yes,
Hmm.
one
If
order
you
will
find
do.
that all of them don't come under one order, writ petition will be dismissed. List these matters again on Thursday as fixed parted items. Heard so and so, so and so, so and so, so and so, so and so.
Much.
May I please, your lordship, the contempt matter notice has been issued and the respondent has appeared also, my lord, but there is no response, my lord.
Who has appeared for the respondent?
Mr. P Naik name has been shown, Mr. P Naik has appeared.
Where is Mr. P Nayak?
Page 34 is the, my lord.
What is the order?
My lord, page 34, in terms of the honorable court's order, I have filed a representation and there are directions to dispose of that representation within 2 months. That has not been done, my lord.
All right, we'll give them just one chance and then personal appearance. Heard Mr. Enhock, learned counsel for the petitioner. None is appeared for the respondent, although the name of Mr. P Nayak and Mr. H. Alia, learned counsel for the respondents have been duly shown in the cause list. Be that as it may, for ends of justice and so as to give one more opportunity to the respondents to appear in the matter, this contempt case is directed to be listed again after 10 days. It is however made clear that if the respondents' counsel remain absent even on the next date fixed so as to answer the court's query, this court will consider directing personal appearance of the concerned official.
May it please the lordship. Lordship, in this contempt petition, my lord, we have been served with a speaking order by the respondent, my lord. Therein, they have, my lord, declined to consider our prayer as granted, as directed by the court, my lord. Lordship will find the direction, my lord, at the page 10, my lord.
The notice has been served.
Yes, my lord. They have also appeared, my lord. Name has been shown. And my lord, we have also received the speaking order, my lord.
Speaking order has been issued.
Is issued.
Then we'll close it.
My lord, we may close
Huh?
it. My lord, we close it.
Yes. Heard Mr.
MHO.
M.A. Chaudhary, learned counsel for the petitioner, none is appeared for the respondents. Mr. Chaudhary, however, submits that in terms of the order dated
10/1/2022, my lord.
10/1/2022, passed by this court in WPC number 5432/2020.
Lordship, in this matter,
They are appearing.
yes, Lordship. In fact, the speaking order has already been
Yes,
passed.
that's what is, we close it. And then you write Mr. K.P. Patel, and counsel has appeared for the respondent. Mr. Chaudhary submits that in terms of the order dated 10/1/2022, passed in WPC number 5432/2021, a speaking order has already been issued by the authorities, and therefore this contempt case can be closed. Mr. Pathak has also produced a copy of the speaking order dated
10/1/2023.
10/1/2025. In view of the above, this contempt case is closed.
For hearing item 18.
This is the matter, my lord, where the petitioner is challenging an alleged forced resignation, which was imposed upon him, my lord, where the
So this
respondent.
is a new matter.
It's of
We
2011.
will not start it today then. It has to go on some other date. What is the issue here?
My lord, the petitioner was forced to resign from his services, my lord. That is under challenge. My lord.
Can you tell me when this matter can be fixed? We'll have it next Thursday.
Yes.
All right. Mr. R. Majumdar, learned counsel is present for the petitioner. Mr. H. Gupta, learned counsel has appeared for the respondent. Considering the fact that the lead petitioner is out of service and this matter pertains to the year 2011, on the request of learned counsel for both the sides, let this matter be listed again on 22nd of June 2023 as a fixed item for hearing.
Item 19.
This will also require a fresh option. But here, the petitioner is in service.
Connected.
Malad?
Connected.
It is
matter.
not connected, my lord. Here the petitioner is in service and the disciplinary proceeding is under stay, my lord.
Then let it go after vacation. Mr. R. Marinda, Learned Council appeared for the petition. Also had Mr. B. Chakravarti, Learned CGC representing the respondents. On the request of Learned Council for both the sides.
Lordship, can it be fixed on 20th July,
Let this matter be visited again on
27th.
27 July?
27/7/2023 for hearing as a fixed item.
Item 20.
Malad made this lordship, Malad, this matter realized to Malad, dismissal from service on account of unauthorized absence, Malad. Initially, the repetition was heard and the repetition was dismissed. Against that, we filed appeal, Malad, an appeal that has been allowed. And Malad remanded the matter for fresh consideration, Malad. So Malad may fix a date, Malad, Thursday, Malad, next, Malad. Thursday, Kimber. Thursday, Ketari. Not on 22nd, any other day, 22nd, some other matters are fixed, any other day. It may be on 20th, on 27th. Yes. Yes.
27th will do it, but tell me the next date, 27, there will be no question of any hearing of these matters. So you also tell me the date in July or August at the same time.
Let it be July prior to the candidate be, Malad, because Malad, there's a small argument will be there, Malad. Short argument.
Due to paucity of time, final hearing of this matter will not be possible today. As such, on the request of Mr. B.K. Das, Learned Counsel for the petitioner, as well as Mr. R.K. Dev Chaudhary, Learned DSGI, registry is directed to list this case again on 27th of June.
Obliged.
As a fixed item.
Regarding hearing this item number 1, and also directly will be for the judgment as well as the gist of the case. So I have prepared, but I can submit.
Today it may not be possible.
No need. You also hard it. I will submit to you also.
Hard it, which matter?
I just four. It has been hard by you. You also directly to some judgment.
All right.
And as well as the gist of the case.
You keep it with yourself. Tomorrow we'll try.
Tomorrow I will go out, that's all.
Then day after tomorrow.
All right.